Sir, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, sir.
On March 28, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle and began walking to the residence where the murder suspect was. The officer's supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there.
Stop. Oh, sorry.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant. Ordered him to stop. He refused to stop going towards the residence. Your Honor.
Did it serve the warrant? What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence, and that's been this incident.
Read it again, if you don't mind.
Yes, Your Honor. On March 28, 2025, the law enforcement officer and squad 5 of the Houston Police Department's gang division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant once again ignored the officers. The law enforcement officer grabbed the defendant and made him bounce and the ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what. So I was originally reading the summary. I'm going straight from the gems now, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that the suspect, that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor.
I find no problem causing your case. Just be careful, man. When you get into a pissing match with
I understand.
who's going to win?
They are. I understand.
No.
Yes, sir.
Hand it.
Fine. Sit down.
Please. You are on bond for an assault in this case, and you've now picked up a new case. What happened to the violation of protective order, please?
Yes, Your Honor. On March 18, 2025, Harris County, Texas, the officer met with defendants for a BPO call from service. The officer met with defendants when he filed with the defense center, learning text messages and called her 21 hours. Claiming received calls for 1 day after the 61-day protective order expired. The defendant has no contact order in place out of Court 5.
You don't get it. You don't get it. I only have one thing to do. I'm sorry, I'm revoking your bond, putting you in jail. I ordered you not to do something and you're doing whatever you want to do. Doesn't work like that. There are serious consequences. Goes with you. This is Montes.
Did you want another motion?
Yeah.
Okay.
Yeah. Oh, I'm putting a new MOA on him and I'm going to advise him that if he violates it again, we'll have a hearing to hold him at no bond. Okay. Because the second one, I can have a hearing. I will only touch the assault case and I'm going to put it at 5,001. He has made bond on the VPO.
He was given PR.
They gave him a PR bond on the VPO. It's like, I don't know if I'm going to keep the PR bond on the VPO as well. This room, just.
Well, Judge, there were multiple orders in this case for bond conditions, and the one that ordered no contact was not labeled an order in the computer, so I didn't see it. There was another one that was no threatening or harassing, and a third one, and it was blank, and all it said was all conditions to be supervised by the department.
That means they're following the conditions in the state's motion filed on that same day.
Say it again.
Oh.
That
okay.
order will mean that they're supposed to be following the conditions in the state's motion that are filed on the same day as that transfer order.
Tell him ad nauseum, you know. I'll leave the VPO as is, okay?
Yeah.
I'm putting a new protective order in today, and I'll advise him that he's not to have contact with this person. And if he does again, I'll have a hearing to hold him at no bond. Okay? So yeah, the VPO, he's made bond 2,500, and at the assault, I'm putting it at 5,001. Okay?
Thank you, Judge.
Good morning, Mr. Jordan. So you're charged with interference in the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 27, 2025, an officer was working a second job at Dick's Sporting Goods in Harris County, Texas, and was approached by the store manager, the witness. He was advised that the officer, the defendant, walked into the store with another individual, and the witness advised the officer, the other individual with the defendant walked out of the store without paying for any merchandise. The complaining witness stated he wanted the defendant to trespass because the defendant was seen on camera attempting to cover the individual while the individual was stealing merchandise. The officer stopped the defendant at the front entrance of the store, and the officer stated the defendant would be trespassing the store. The defendant became irate and more aggressive. The officer ordered the defendant to place his hands behind his back and placed handcuffs on the defendant's right wrist. The defendant twisted his body and tensed his muscles. The defendant, with great amount of force, threw his left arm forward and threw his left arm backwards towards the officer. The officer attempted to gain control of the defendant's left arm. The defendant began pulling away, and the officer grabbed the defendant's body with both arms and guided the defendant toward a rack where the officer was able to excuse me, Your Honor, tongue twister, where they were able to detain the defendant. The defendant was identified by his Texas driver's license.
What's he under arrest for?
I believe he was under arrest for trespass originally, Your Honor.
Oh.
We have,
You gotta,
yes, Your Honor. We just have a brief moment.
are you losing? Are you losing?
Your Honor, the only thing I have is that the suspect began acting irate and clearly becoming more aggressive, and then the officer went to detain the suspect by grabbing his right wrist.
No. Alright. When you get into a pissing match with the people who have the power of arrest, who's gonna win every single time? You know what I mean? Every single time. Sometimes it's better to tuck your tail at times, because you may end up winning in the long run. I'm gonna find no probable cause in the case. Just be careful, man. I probably wouldn't go back to the sticks because it's not gonna go well. You know what I mean? All right, hang tight, please.
I am here on Destiny Drake Osby. Yesterday, you ordered that she appear today. I was appointed last Friday. She caught a new ag assault family member in another court.
Now,
She is in court eight's holdover right now.
do you mind bringing up please?
Last name is Drake-Osby. The case before you, like I said, it was recently appointed a week ago today. It looks like the arrest was the following day for whatever this new thing is.
This is for the,
Well, no, the new law violation that she caught in felony
let's,
court.
hold on before, because I want her to hear.
Gotcha.
I'm in shock. On bond for DWI with us, and you've now picked up an aggravated assault on the family. You might, this is Ms. Drake Osby. What happened in the ag assault, please?
Yes, Your Honor. On April 1st, 2020, as first specified, the plain was the defendant are exes from a prior dating relationship. On April 1st, 2025, an officer was dispatched to an address in Harris County, Texas, responsive for service call. The complainant stated there was a verbal altercation when the defendant took the complainant's cell phone. The defendant then entered the bedroom and began striking the phone with objects to break it. The complainant was able to retrieve his cell phone, at which time the defendant began to strike the complainant in the head and torso with a close fist, causing him to fall on the ground. The complainant was able to walk away, and the defendant grabbed a metal object and struck the complainant in the head and arm, causing 2 lacerations on his left eye and a laceration on his right eye, and multiple scratches on both arms. The defendant then jumped the fence and fled the scene. The object was a solid metal bracket, 12 to 16 inches in width, made of heavy gauge service iron hold, 2 cylindrical metal tubes, and has multiple sharp triggers. The item is manufactured for law enforcement officer use as a mounting or deployment device for entire population.
And all this over a phone? Ms. Drake Osby, I now have to revoke your bond in our case as well. I'm sorry. So I'm gonna set it at 5,001. You've still not made bond on the felony case. So if you do, I mean, we can talk, but John, I think he's set for when? She's set for,
514, Your Honor.
yes, sir. Okay. Do you want to do, I guess, the day after then?
You look at one other thing, Judge.
Well, I think the felony is actually set for Monday. Our case before this one was caught up was when she was reset for 514.
It's up to, I'm good with whatever you want to.
I'm actually looking, I don't have any new discovery to look over because this case is so new. There weren't even any body cams for me, so I'm pretty much waiting on everything. I'll leave it where it is and I'll monitor things and see what's going on with the felony case, Judge.
All right. Thanks.
Thank you.
Constitutional question. When the homeowner walked toward his own residence during a capital murder warrant execution and was physically taken down by officers, the judge ultimately found no probable cause. So here's the question. At what point does a citizen's right to access their own home end and law enforcement's authority to restrict that access begin during an active felony operation?
So I've got a couple to talk to you about.
Okay.
Start with the easier one first. Mr. Ally, he,
Marquise Heller?
yes,
Is he in custody?
no, he's on bond. He had a violation because apparently he was doing random drug tests.
Oh, right. Is he here?
He is here. He went and he's tested. He came back negative, which is positive. But I think there was a miscommunication or a misunderstanding about him having to go drug test. He's got a pretty extensive orange sheet. And he's doing a mental health PTI, which
Remember?
he's done the interview. We're just waiting on the report. So I think it may have just, when he missed the drug test, just a misunderstanding, miscommunication as to what the bond conditions were.
Edward Johnson?
Did you get the report on Ally yet?
I haven't gotten one, but I did speak with.
Waiting. It's been a long time.
Well, they do them in batches rather than piecemeal. And so we just,
I mean, he went and did it at least 60 days ago, no?
I don't think it's been 60, maybe 30, 45-ish, but he has gone. I did speak with the Harris Center and he,
I remember you telling me that it went.
yeah. We're just waiting, and the Harris Center, I know that they're very overwhelmed and understaffed and
I get it. What do you want to do?
what, like I said, he's here. His clean, if we
That's
could,
good.
yes.
Okay. I mean, he's clean, which is great.
Yeah.
So let's set it, I don't know, maybe a week.
Okay.
If it's not back in a week, I'm going to call it. I'll figure it.
Okay, perfect.
Who's next?
Mr. Jorge Pena, he's in custody. He has a fugitive case,
Is it what case?
a fugitive case.
Okay. Oh, hi,
And,
Amy.
he would like to speak to you about getting a new,
About a bond?
he wants a new court appointed lawyer. And
Do you mind bringing out Jorge Pena, please? Pena, please.
I don't want to presume to speak for the court,
Is it
but
upset with you? I find that really hard to believe, really.
Judge,
Can you go to bat? So I don't get it, right?
this is the first
He
time.
thinks he can get a different result. Is it just because of the fugitive case?
So he has a fugitive case and a local case, which makes it a little more complicated.
He's made bond on the local case, which is good. So the 15 days, did he waive or did he refuse? Okay. He looks young. Huh? Rick, did you find something?
Oh, Judge, I don't have the website, Judge. You can pass that along. I'll try.
You what?
I don't have the website.
You are, okay.
Judge,
Let me just make sure.
the local system says it won't work.
Say it again?
The local system said that it will not work, within 48 hours of them being placed into U.S. custody. I'm not sure if it has been the last 48 hours that she's been detained by ICE.
You want, hey, it looks like I've got the boyfriend here. Do you want me to get the phone number for this person and I'll give it to you, Rick? You can talk to him? Or have you already talked to
I've
him?
been talking to him, Judge. I do have it.
And what's he saying?
He says that tells me that ICE has her.
That ICE has
I
it.
don't have any. Yes, I don't have verification of it.
Okay, so why don't we do this? Because, state is saying that within 48 hours of them taking, they can't verify it. I guess it takes a bit to hit the system, you know?
Oh, I see, yes.
And
Mhm.
when did they allegedly get her?
Yesterday, it showed that she was out on bond, but she didn't appear yesterday. So apparently,
Judge, if you'd
maybe
like
a
to
couple of days
contact-
before.
State of Oregon?
It does give a number for the field office, if you'd like me to reach out and contact them.
Yeah, but you got a lot, I mean, you got a lot of stuff here going on, you know?
County doesn't have a right, Judge?
Yeah, I don't know. I don't know if you can, you should get that deeply involved, in it, you know what I mean? Because I don't want you to do something and you get in trouble, so. The hold was lifted 3/16. Rick,
Okay, Judge?
so that's been 2 weeks.
Wow. So apparently that's where she's been. I've had no contact with her, Judge.
I mean,
But,
if we can't verify that she's in custody, because I can't, then I'm gonna revoke the bond.
Right. I understand.
So I guess,
Maybe-
do you want to see if the guy that's here can provide proof that she's in other than his word?
Right. He tells me that he has a immigration attorney for her. So let me speak to him, Judge. I'll talk to him and then I'll get back with you.
He's like a folder with a bunch of stuff.
Do you have his phone number?
Yes, I do, Judge.
Okay. Do you speak English?
Yeah, I think English.
Okay, so her lawyer is gonna call you now. We need proof that she's actually in immigration custody.
Number and everything, force it and everything. She has court Monday, doing my immigration, her immigration lawyer, I'll sponsor her and everything.
Okay, so go out there, speak to the lawyer to see what kind of proof that you can bring us and let us know. And
Okay, yeah, I got all the paper you need. Okay.
he's gonna call you now.
Okay.
Okay,
Will do, Judge. Thanks.
thanks, Rick. Hey, after this, I'll hit you up, Joseph. Pena.
Yeah.
Okay, so Mr. Pena, you were wanted out of another state. And I guess your lawyer there are two things. You're not happy with Anna here. And so we need to talk about number one. Number two, a lot of times when people have fugitive cases, they ask for me to set them a bond so they can get out and go turn themselves in. I don't know. I don't know why you're wanted out of the other state. All I know is that you have an open DWI now. And within the last, year and a half, you've picked up 2 other cases with me in this court. So I know you because you keep picking cases up. So I don't care if you have Jesus here. It don't matter who you got, where she's as that good, right? I don't know if I'm going to give you a bar because all I know is you keep picking cases up. And you're only 23. So, Amy, tell me about Mr. Penny.
Yes, he brought out Newton County, Indiana, from business influence, forgery, fraud, and identity section. This was issued May 14th of 2024. He of course has local cases for DWI, 415. Let me see what else.
What's he wanted for? What was the first part?
Corrupt business influence, forgery, fraud, and then identity deception.
Corrupt business influence, forgery, and fraud. Do we know that they want him?
Yes,
Okay. Is there a bond that's been set there?
I don't have any information about bonds. Also, day is coming up in 5 minutes if we're discussing bond.
Okay. So tell me, what's going on?
Mr. Pena, I don't want to get too far into attorney-client
Sure, of
communication.
course.
He would like to ask for a new appointed lawyer.
Why?
Oh, well, me and her had a conversation. Like, there's nothing against her, but we just had a conversation, and I didn't think that
She's fighting for you?
you could
She's
say-
one of the biggest junkyard dogs that we have here. There's no one that fights more than she does.
No,
She's better than most attorneys I even see here. I'm telling you, she's amazing.
no, I believe you. You could be saying the truth, but
I am saying the truth.
no, I know you are. Believe me. And just off the fact, the cases, the other price case that you did bring up, I haven't had. It was a year and a half already, and it's only been for for protection. Like my other cases, I'm not no bad dude that robbery or they're all gun charges, and that's just on the behalf of the landscaping business that I got. that every time when I'm in the backyard or so, somehow they're always trying to steal the back of the trailer. That's the only reason and the only cases that I got. I don't got no evading arrest, no like robbery or grant or what, however you.
I don't know, but we have another prosecutor that's coming up to speak about this as well. I'm not going to give you another lawyer. This is a lawyer that we've given you. We only have a couple lawyers who do these types of cases regardless.
Okay.
So,
The only thing I was gonna, I'm sorry, I didn't mean to cut you.
Okay.
The only one I was gonna ask you was I was trying to get the lawyer that fought for the two gun charges. I don't know, Mr. Some with, I just forgot. I think he's an Italian dude.
those cases you had,
They have the same guy. And I really thought it was him right here.
oh, it is Greg.
I know I hear him familiar. Yeah.
Yeah, Greg, you represented Mr. Pena on both of his prior cases.
Yeah.
Oh, man.
That's why when I looked at it, I was like,
So, look, the only way you can have Greg is you can hire him. Otherwise, you got Anna. Okay?
oh, he's getting, oh, now he charges
Hire him.
that.
I always charge. I don't want
All right, we're gonna put you back because we're waiting on another lawyer to come up here.
Let me go back and talk.
For sure.
Good morning, or good afternoon, whatever it is.
What happened, Dave? Are you upset
Too
with
late, Judge. I didn't, I missed that you set a $5,000 bond on Anna's other client.
Look, I didn't see very much violent history. I saw that this is yes, but it's been 5 years since he's gotten in trouble. Did you have something to add? I'm all ears.
Well, I let Amy prepare it, so I'm gonna just let sleeping dogs lie. I just,
I didn't see much violent history. I saw DWI, I saw in a dating, but those back in 15 and 16. You know,
it was I mean, it's already done, so it's, at this point,
do you have something that's truly aggravating that would give cause for concern?
well,
I know the facts of this case, right?
and, well, the argument I would have leaned more towards is not the, necessarily the physical danger, but it's the flight risk of it and the aggravating circumstances of what he's wanted for, but,
Hey,
you know.
if you run, you can't run forever. We'll get you eventually, number one. And the worst part about the case that I saw, gets out of the car, puts her in a full Nelson. I didn't have anything more than that, there was no blood, there's no, the history was,
It was a lot more flight risk and the fact that one of the conditions, well, if we're talking about the warrant,
it was a 2B,
it was a 2B and one of the conditions they asked was no contact, was my understanding, the complainant's in the gallery.
but she came on her own accord.
Well, I understand, but it's the same as domestics here is, I understand that they're obviously willing complainants or recanting complainants, but in the domestic part of things.
But if it's a 2B, he hasn't been ordered by the court. So he doesn't know,
No, I know, and that
he's
was,
not on notice.
no, my argument wasn't, he wasn't violating any bond conditions, that's not what I'm saying. What I am saying is if one of the concerns, right, is that they would go out of their way to put it in the teletype and to the warrant to us, that it is a concern that they have contact, is one of the things that would facilitate and ensure the no contact instead of him being free and odds cash in my pocket says,
Yes.
right, but cash in my pocket.
And Anna's gonna let him know, so that he now knows.
But anyway, all that said is it's already done, so I'll move to the next.
Okay, Mr. Pena, thank you for moving that over. He would like to ask the court for a fugitive bond. I told him it was a long shot, but I was not going to presume to speak for the court.
We need to bring someone out. Pena, please.
You want to record or get some?
Hey, Vic, you want to go through the list? Or no? You're not ready?
Well, you weren't here yesterday.
That's true. That's true. So wildly sleep deprived. It wasn't too bad last night. It was a steady flow. Not too bad. So tired. Yeah. It's good fun.
Three on one, two, yes. Two subjects.
Did you want to go over to? Page 5, Davis. Set or ring and fell to a few first time.
2501.
Right, page 7, Estrada. Oh man, how much is that?
5001 on the DWI.
Ready for the next one?
No, give me 1 second. Let me finish the bail order.
El resolution.
Okay, who's next?
Next you got is page 13, Jenkins. That already felt to be a concern.
2501. Okay. I'm not happy with you, and the thing is that, Mr. Pena. Since you've been an adult, you've picked up 1 to 2 cases every year. It would scare me to let you out because I don't know what you're going to do. The last thing I want is for me to let you out and you leave just a path of destruction like the Tasmanian devil. You now have a DWI here. You're wanted for 3 charges in, where was it again?
Indiana.
In Indiana. You're hopscotch in states with criminality. And you're only 23. I don't feel comfortable giving you a bond because I don't think that you will comply with the court orders. Sure, just don't talk about the cases.
Oh, no, I'm not talking about, sir, believe me, I understand where you come from, because probably not the first time you see it, but, my cases are not, never hurting nobody. I'm not a menace to society.
What else was it?
Your Honor, it's fraud, identity deception, forgery, corrupt business influence,
But nothing with, no disrespect to you, I promise, no disrespect, but nothing that has, that I hurt somebody or make somebody do that they didn't want to, or like
Have an open DWI.
for doing a favor.
Stop.
Oh, sorry.
Yeah, don't.
Yeah, sorry.
If you go out there and you kill a family of 4, do you think, well, he was going to try to help someone? Do you think they care?
Like, I was asking her, I was like, at least, because my mom, it's the Indiana case is like 14 hours if I'm not mistaken, and well, my mama don't got enough money to be going back and forth. So that's why I was asking her. I'm like, if he, I'll do anything that however he feels comfortable, like however you want. I was like, can he at least put me a monitor to drive with my mom over there at least one time? Because I haven't seen my mama, and I'm not gonna be able to see my mama if I end up going all the way to Indiana because she don't got enough funds to even go over there like every week. And sir, like, believe me, I'm not no bad person.
Concern is whether you get to see your mom. You know what I mean?
Understandable. No, that's understandable. No
My
disrespect.
only concern is that you get to Indiana to
Yes, sir.
get charges.
Yes, sir.
Now, the problem is that you refused extradition. So you aren't even earning credit now towards, because when someone waives extradition, we give that other state 14 days to come get you.
Yes, sir.
And if they don't come get you,
Yes, sir.
then Harris County releases you,
Yes, sir.
right? The warrant don't go away.
Yes.
That warrant will also remain.
Yes, sir.
But at this point, I just don't feel comfortable giving you a bond, Mr. Pena. You're just too young. You keep picking up criminal cases and it scares me.
Well, can we come to like an understanding? Like, let's just say I do suppose, like, however you think that I'm finna do, I'm really eventually I'm gonna come back and I'll do more time than I have to. Bro. I'm giving you my word that I
don't feel comfortable, Mr. Pena.
That's acceptable. That's acceptable.
The problem is that with the cases that you had with us, I also had to revoke your bond on those cases when you were just here with us.
Yeah,
You failed to appear on one of your cases, and that's just here in Harris County. On one of the gun cases, you took off and we had to issue a warrant for your arrest.
No.
No.
Okay.
And Judge,
The bond at 1,001.
just if I may, I believe both of the gun cases were ultimately dismissed.
One was dismissed, the other one.
One was not.
Oh, okay. I apologize for my misunderstanding. I thought they both.
So he probably pled to one where they dismissed the other one.
Okay.
He was on bond and he picked up a new case. That's what it.
No, it was a
No.
year after. But actually, in part of housekeeping, if you wanted to go forward with the 2-year rule, or if you didn't want to.
Okay. So his DWI is in court 15. I don't know if they're gonna send that back because of the.
We killed the 2-year rule.
Oh,
Oh,
didn't know that. Okay.
Yeah, it what was it, like a month ago or so?
Oh,
Yeah, so there's no more.
Okay,
It's still like all fresh and new. We have to update the court rules, but as far as
okay,
the 2-year rules now, gone.
okay.
Yeah, because the problem was is that judges would get too, you'd end up seeing the same people over and over, and then is it really fair because you end up, right? You
That makes
start
sense.
developing a relationship and you start treating them differently as you would.
Right.
So that's why. So now you refused. I'm not going to give you a bond. So you have two options. You can, if you want to continue to refuse, they will go get a governor's warrant from Indiana to forcing Indiana to come get you, but that will take 90 days. If you want to waive now, you can waive now, and that'll give them 14 days to come get you. I'll let you talk with Anna to make the decision to let you know what you want to do.
And he did sign the waiver, just,
Oh, okay, all right.
so.
Time started yesterday.
Just start
Right now,
So they'll have.
the time that you waive,
they'll have-
which is right now.
Yeah, I had signed a paper, yesterday, if I'm not mistaken. I sure did. Cause she said it starts at 12, that day that I signed my paper.
It's up to them whether they want to.
Oh, I'm sorry. Yeah, at
No, it
first,
shows a refusal.
at first it was I had signed for the 90 days, and she said tomorrow you got an option to tell your lawyer that, you could change your mind tomorrow.
Okay.
And then I was like, when did the day start? She's like, tonight at 12.
It's a refusal.
Yeah, so they'll have until the 18th.
Oh, no, it's okay.
Yeah.
It's okay. No, you can
Yeah.
worry about it. I appreciate it.
Okay.
You're doing your job. Appreciate it.
Thank you, Judge.
Appreciate you, Judge.
Take care. Good morning, Ms. Hodge. Ma'am, you're charged with resisting arrest or search. You're facing up to a year in jail and or a $4,000 fine. We are going to do a probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be pointed to you. Okay.
Your Honor, on March 30th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 55 miles an hour in a 40-mile-an-hour zone and made a traffic stop. Upon contact with the defendant became irate and demanded the law enforcement officer's name and badge number before answering a FaceTime call and becoming distracted. The defendant advised that her driver's license was expired and that she only had a passport. Vehicle registration was also expired. Law enforcement officer asked the defendant to step out of the vehicle and the defendant ignored the commands. Law enforcement officer then opened the defendant's door and again ordered the defendant to step out of the car and informed her she was under arrest for interfering with public duties. The law enforcement officer then removed the defendant from the driver's seat and forced the defendant to the ground. After being detained, the defendant refused to get into the back of the law enforcement officer's vehicle and began to kick out towards the deputies. In the process, the defendant struck the law enforcement officer in both thighs several times. The law enforcement officer were eventually able to force the defendant into time.
She gets charged with assault on a peace officer?
No, Your Honor, she did not.
Very lucky. Extremely lucky that you're not charged with 2 additional felonies. Ms. Hodge, I'm going to find that there's sufficient probable cause to go forward with your case. So can you run her license, see if she has a valid license, please? If you do not have a Texas driver license and a liability insurance in your name, you're not allowed to drive, and I will make that a condition of your bond. When you get into a pissing match with people who have the power of arrest, who wins? Right. Take that into account. A lot of times, something like this ends up in a ticket, you know?
She's not eligible.
Okay, you're not allowed to drive. I'm making that a condition, and you're now going to sign an affidavit with me today, which is a promise that you're not going to drive. I don't care what's going on in your life. There's no justification you can give for driving. I don't care if there's a burning building and you have to save 50 people. Do not drive. If you want to drive, go get a license, get insurance, and I'll happily take this restriction off. That's the only condition I'm placing on you now. Don't drive unless you have those, and then you get approval from us. Because you have a lawyer, Ms. Hodge, I will waive your appearance. Meaning you don't have to waste your time coming to court, but you must stay in touch with Ms. Barnes. She'll tell you if and when you have to come back to court. If she tells me she cannot get a hold of you because you're playing games, you're not responding to phone calls or text messages, I will issue a warrant for your arrest as well. Okay, so I'll have you come up here, swear to us that you're not going to drive, and after that, you guys are out of here. So thank you.
Thank you.
You are Mr. Judge.
Watch out.
Yes, you were charged with racing on a highway. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 30th, 2025, in Harris County, Texas, a law enforcement officer was informed of a group of modified vehicles were going to be racing on the West Loop South Freeway. The law enforcement officer, with the location observed, vehicles traveling in a pack and began to trail the vehicles. Law enforcement officer witnessed 4 vehicles line up side by side at match speeds of 60 miles an hour and then simultaneously accelerate to speeds over 100 miles an hour. 3 of the vehicles that lined up and participated in the second drag race. A traffic stop was initiated and the defendant stated that he was only speeding.
Do we have any of the co-defendants?
We do not, Your Honor. I believe
Who's the only one?
individual was detained on the traffic stop from another officer.
Do you mind running his license, please?
Yes, Your Honor. Your Honor, I do not currently have a driver's license. So take it to me.
Mr. Huarcha, you are not allowed to drive. I am putting this condition on you now, and you will be signing an affidavit with me today, promising me you're not going to drive. I don't care what your excuse is. If I find that you drive, if you become a danger to my community, I'm going to put you in jail. I don't know if you're in this country with permission, but if you're not, and you go to jail and immigration finds you because they sweep it daily, they will put a detainer on you and you will be stuck like Chuck in there until this case is over with. And then you get shipped off to immigration. That's usually about a 6 to 9 month process. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. I'm absolutely serious when I mean no driving. I don't care what your excuse is, sir. If I find that you get into a car and drive, and I don't care if it's to the little Piggly Wiggly, it's not going to go well for you. I'll have you come up here, swear to us that you're not going to drive. We'll have you sign a reset. And after that, you'll be out of here, sir. Thank you. Thank you. Sweet. Have a wonderful day.
This
Good morning,
woman
Mr.
was pulled over for speeding, had no license, no insurance, and when ordered out of the car, she refused, kicked officers, and struck a deputy multiple times in the legs. Yet she walked away with 0 assault charges on a peace officer. The judge himself said she was extremely lucky. So the question is, when a citizen physically strikes a law enforcement officer during an arrest, should prosecutorial discretion to drop those charges be limited? Or is that flexibility exactly what keeps the justice system fair?
Good morning, Mr. Robichaud. Sir, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On March 29, 2025, the officer was advised, an officer was advised that the defendant exited a Target store with approximately $100 shooter, passing all points of sale without attempting to pay for it. The officer arrived at the store location and was advised the defendant placed a scooter in the rear of his motor vehicle and drove away with the The officer initiated a traffic stop in the vehicle and detained the defendant. The officer observed the scooter in the back of the vehicle. The officer confirmed the scooter was stolen by contacting the complaining witness, and the officer identified the defendant by entering his name, date of birth, and used a prior booking photo to match the offense.
Can you run his license, please? See if he has a license.
Yes, Your Honor.
It's expired, sir.
Stop.
Your Honor.
Mr. Robichaud, I'm going to have you sign an affidavit with me today promising you're not going to drive. I don't care what's going on in your life. I don't care what you need to do. I don't care what the kid has to go. They got to go to the hospital. You're not allowed to drive unless you have a Texas driver license and liability insurance. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car. Do you understand?
Sir.
I'm also ordering you from going to any Target whatsoever, anywhere.
So I do have a valid insurance. I need to renew my license. Absolutely. I agree.
If you have valid insurance, but you still don't have a license, that valid insurance is squat because you don't have a license.
Sir, I understand. I know I made a mistake. Yes, sir. Huh?
You have the ability to hire a lawyer.
No, sir, not at the moment.
Brandon's going to give you an application. I'm going to have you fill it out and I'll see whether you qualify. I need to know everything about you. We are going to make bond conditions for you not to go to any Target. You're going to sign it. Do not pick up a new case. Do not endanger my city. Otherwise, I'm going to make your bond so high. Do you understand?
Absolutely.
Don't pick up any new cases.
I appreciate it, sir.
All right, head on over there and then we'll have you fill everything out, sir.
Okay.
Tell me about it.
This is a fugitive case. He's wanted out of Escambia County, Florida for assault battery.
Only burglary with assault.
Oh, burglary with assault battery.
Felony, burglary, assault, and battery. Okay?
But I believe it's one charge, not multiple. And he has asked me to ask the court for a bond. a
Okay.
fugitive bond.
Do you mind bringing him out? Get you going, please. Lemonias. Please. Mr. Lemonas?
Yes, sir.
Lemonias. Good morning, sir.
Sir.
Your lawyer is asking for me to set you a bond. I don't know. I've never met you before. All I know is that you have a charge out of Florida and that you have some criminal history out of here. And that's quite concerning because the last thing I want to do is to give you a bond and you go out there and leave a wake of destruction on the way to Florida. I have enough trouble sleeping as it is. That's not what I want. So it's really hard sometimes to figure out who should we give a bond to, who should we not give a bond to.
Understandable, sir.
So State, tell me about him.
Yes, Judge. He's wanted out of Escambia County, Florida for felony burglary with assault or battery. State's asking for no bond in this case. This was issued, while it was issued March of this year. We're concerned about the facts around this case. It seems that the complaining witness on this case knew the defendant in some kind of relationship, family unit. In this case, complaining witness was inside a car. Defendant went to the driver's side of the car, opened the door, grabbed the female by the legs and dragged her out of the car. Put her in something such as like a full Nelson. So we're concerned about the danger to his complaining witness in this case. Furthermore, we're concerned about the criminal history related to this defendant. He does have a bond forfeiture out of our court. He's also been a previous out-of-county fugitive from Galveston. He has some other criminal history.
Does he have anything else open anywhere else?
He had a criminal mischief that he was convicted of in 2021 out of Galveston, a resisting arrest from 2019 out of Brazoria. He had a probation revocation in 2019 for Brazoria, DWI second, 2019 for Jefferson County. He had an evading motor vehicle from Harris County deferred revoke in 2016 because he had picked up 2 new cases, one which was a DWI from 2016. That's all I have, John.
Judge, the complaining witness in the open case, she's here today in court. I know we don't want to get bogged down in the facts, but she is here today. And yes, he does have some history, but most of it's over 5 years old. Nothing too recent.
The criminal mischief is 2 years old out of Galveston, right? You said it's 21 or?
2021.
2021, so that's 4 years, sorry, I rounded up. So he's not had any contact with law enforcement for 4 years. He's working as a tanker. He works, changing out the seals in the tanks. If he is allowed to pay the fugitive bond, go to Florida and resolve this, then that helps him keep his job.
I don't know. I mean, I truly don't because while he's got some criminal history, it's not a couple years ago, but it's a new case and is it 1 felony? Is it 2 felonies?
It is 1 felony. It's burglary with assault or battery. This is the name of the charge. I do also want to mention on the warrant, it says no contact with the alleged victim. So.
They're telling you not to have contact with the victim in here,
That's okay. Speak your mind.
Let me say something, Judge.
Don't talk about the case because they can use it against you, but
She's not under the court order. If she wants to come, it's only him that has to stay away from her. I did not notice that.
did you want to say something?
Do I need to say it to you, guys? I don't know who I.
Just don't talk about the facts of the case in Florida. That's all we're going to say, because anything you say there, you have the right to remain silent. Anything you say, they can use against you. I live stream proceedings, so, people may see it.
If we want to step back in there and you can tell me whatever you need to tell me, I just don't want to.
Sure. Okay.
Judge, without getting too bogged down in the details, of the fugitive or the underlying case, my client also is an Army veteran with an honorable discharge. He's 100% disability from the VA. If you give him a fugitive bond, he's going to go back to Florida because he's got too much to lose if he doesn't.
Is he on bond for this or is it 2B?
I believe it's a 2B.
2B. The state of Florida is requesting no bond until first appearance.
Say it again?
The state of Florida is requesting no bond until first appearance.
Mr. Lemonius, I will give you an opportunity to go turn yourself in. But I'm going to tell you now, I'm not going to do this again.
Sir.
Everybody tells me that. Everybody tells me if I had one strand of hair, every time someone told me, I'm not going to do this, I'm not going to do that. The actions speak louder than words. You telling me this means absolutely nothing because you have rich criminal history, man. And now you got a new case in another state and you're here. So you telling me it's not going to, I mean, really, at what point is it going to take for you to realize that, you know, if you have anger issues, you need to address it. If you have substance abuse issues, you need to address it. If you truly are a veteran, there are services available for you to be able to deal with these things. It's a matter of you wanting to do it, you taking the initiative and being proactive before they put your ass in jail and force you to do it. Is that what it's going to take?
Sir.
Everybody tells me that until they're wearing orange like you are now. Courts really notice when people take proactive, meaning they do stuff on their own to try to address any issues. It really goes a long way. Now, as far as a bond is concerned, I'm not giving you a low bond, but I will set you a bond. I'm going to set you a $5,000 bond. Okay. If you do make it, we give you 2 weeks from your release to go turn yourself into Florida. If you fail to do it, you are old enough to understand that actions have consequences. And I'm telling you now, I will not do this again. You ever pick up a new case, if you fail to turn yourself in here, I will revoke the bond. I'm going to set it at 0. Like I said, you won't get another one. And this time I will hold you. And I tell you now, we've had cases where it takes damn near 90 days to get Florida to come down here to pick someone up. You understand?
Yes, sir.
Okay.
Your Honor, I will note Dave is coming.
Hmm?
Dave's coming up in 3 minutes, besides.
Okay. All right. So so you can put it back for now. Let me see what Dave has to say. I don't know if he has anything that's going to change my mind, but we'll see. Okay.
Yeah.
Hey, hold on. Calmate.
And Your Honor, he has a bond violation. He picked up an evading on foot.
You are on bond for a DWI. You've now picked up a new case. When is it going to? Let's go through your history, shall we? From 07, reckless driving, suspended license 12, suspended license, assault, VPO, felony continuous, endangering a child, ag assault, reckless driving, now DWI. And while you're on bond for DWI, you've picked up now evading arrest. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please.
Thank you, Your Honor. On March 30th, 2025, in Harris County, Texas, a law enforcement officer witnessed the defendant recklessly turn and nearly strike the law enforcement officer's vehicle. The law enforcement officer initiated a traffic stop and the defendant evaded, as the defendant stated, the defendant evaded for 150 yards in the vehicle before being stopped. He couldn't go any further due to a valet parking lot. The defendant then exited his vehicle and fled on foot for 200 feet before being detained by the law enforcement officers.
So he almost hit someone. He's driving.
It looks like he almost hit the law enforcement officer.
So they attempt to pull him over
Yes, Your
and
Honor.
he takes off. He gets out of the car and takes off.
Yes, Your Honor.
Did we have a no driving affidavit on this case? Do you know?
No, Judge, but we can have a condition. Don't drive unless you valid insurance license.
Does he have a valid license?
I'm rerunning it now, Your Honor.
I don't know. If he doesn't, I don't know how we don't have a no driving affidavit.
Your Honor, I believe this numbers be incorrect. It's coming back. The number in here is coming back as eligible average for a different name and shows that whoever had this number was reported deceased. So whatever driver's license number, that's right, Your Honor. I can see the picture now. This is an incorrect driver's license number that I have.
Mr. Estrada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now revoking your bond on the DWI. It goes with you. I'm now taking you into custody. And I don't know what I need to do to get your attention. Hopefully this is it. But all I want are my streets to be safe. And it's over to the tune of now 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Goes with you.
Your Honor, if I'm able to find a bondsman this morning, would you allow a walkthrough?
No, dudes.
I understand, Judge. Thank you.
Thanks.
It's, this one is gonna be on Mr. Zelaya, Kenny Zelaya.
Because he took off.
Therein lies the dilemma. I am going to ask you for a bond, and yes, I know you are going to say, how do we guarantee that he?
Delia. Let me talk to him. I don't mind.
Okay.
He's with one FTA.
I know, but
So I'm okay giving it to him. I just want to admonish him that I'm not going to do this again.
he knows his aunt's address.
Are you guys opposed?
Your Honor, I mean, from what I understand,
Tell what,
So,
what's your,
yeah, we want to give him mental health treatment that he needs. If compliance is a concern, then, maybe a GPS monitor might be a good suggestion.
Okay, okay.
But I think the priority here is to get him into mental health treatment, which we can't do for.
so I'll admonish him that we're not going to play this game again. I'll give you another one. Please go. If you go, good things will happen.
Judge, no objections on, he needs a GPS, just to make sure if that gets him out so he can go to the appointment at the Harris Center, that'd be great.
Judge, if I may, I believe we can file an order of release and have the Harris Center pick him up from the jail.
Oh, well,
Yeah, that's
That's jail.
code. I've never had y'all do that. That's fantastic.
So we can sign a PTI contract once that's signed. We can file.
Smells right. It's awful.
Well, Judge will.
Yeah.
let's
It's not supposed to be fun.
decide, but
love it.
We'll see what he
The thing is that all we ask you to do is show up. And when you don't show up, this is what happens.
I'm pretty bored.
Why? We're not going to bite you.
All y'all look
Never
fancy.
been to court. How do you know what happens?
Y'all
Oh,
look
man.
too fancy for me.
Come
Not for me,
really
right?
got stripes like a clown suit.
No,
Yours mine's fancy too.
yours too, though.
So what are you doing with yourself these days? Who are you living with?
Right now, it's staying with friend's house, and then,
Where, do you have mom and dad around?
well, mom passed away at 9, when I was 9 years old. So,
Pop
and
around?
dad, he's not in the picture. Like, every time I go home, I have problems at home. Like me and him, we fight, fist fight. We just don't we can't stand each other.
I want to let you out, but I have to make sure that you're not going to run away. Because when you run away, bad things happen. That's why we put you in jail, because you just didn't come back.
I work at Subway.
Okay, great. But I still need you to come back. I don't care where you were. You still have to come back.
Okay.
So we can do this the easy way, and then if it doesn't work the easy way, we'll try it the hard way.
Okay,
So-
that'd be great.
What we want to do, the only thing that we want to do is try to have you speak to a doctor, to see how things are going.
Oh.
That's all we would like you to do. And if you do, great things will happen. There's a program that we have where it's called the mental health PTI program, where if you complete it, your case gets dismissed. All you have to do is talk to someone. And if you do that, great things will happen. Can you get that done?
Yes, sir.
Mr. Zelaya, I want you to understand that I'm not going to do this again. I'm giving you another opportunity to do this. If you blow me off again, I'm not going to do this again. You have to understand that no one is going to bond you out. That's why you're stuck there now. You have no one to bond you out. The only way is if you continue to show up. I've given you a lawyer. We're going to give you a cell phone so you can always get a hold of him. Do you have a phone?
Yeah.
There's no reason. Do you
I got a
think
laptop.
do you think we can get the appointment today so we can give it to him on the way out?
Usually my understanding was they get the information on the PTI.
Laya.
No, sorry, I
Oh,
was calling.
okay.
Usually they get the information on the PTI sheet that they sign the contract that they're going to do it, and then they go on their own
How long
accord.
does this take?
Oh, it takes like a month. We usually reset a month, but I thought they just call and set up the appointment once they're out.
And let
then
him
go-
out for a whole month and waiting and just,
It's not necessarily a full month, it just depends on how long circumstances require it. Sometimes it's a day, sometimes it's a month, obviously it's individualized.
I don't know if I'm going to be down for just letting out for a month while we wait for the appointment to happen.
Well, I think it's on him to call and to go there.
Your Honor, from my understanding of it, if.
That's right.
Once we file, and the CLO might have some, I apologize, never mind. From what I apologize. From what I understand,
No, I think you're right, that we give them the contract, they sign it, and then it's on them to go.
That's my last experience with it. So,
Okay.
yeah.
Can we get the contract today?
Yes, Your Honor. And then once we have the contract, we can file those orders of supervision or release and we can raise it to Harrison and Harrison will pick him up.
Let's do that.
And then he can go in today and I
That's
believe,
probably the best course of action.
Harris, pick him up from here, from the
Yes.
county?
yes.
Okay. That's fine. That's, yeah, whatever the court wants.
That way we know what
I can do
happens.
that.
Okay, let's do it now.
Okay, cool.
Yes, Your Honor.
So, go ahead.
I'll let you explain it.
No, nothing. It's not about this.
But you explain to Mr. Zelaya.
I will explain it.
We're working this agreement for you. It's this diversion program that once you have this interview, the case goes away. But you have to get the interview done.
Yes, sir.
It's going to take me like at least a day or two. So give me a little bit, but we're working with you to try to get the best thing for you.
Yes, sir.
Okay?
Might be Monday, okay, but you're gonna get out. But you gotta do what's they're gonna do, okay? You got it?
Yes.
Okay.
I trust that you're going to do it. Oh,
Yes, sir.
I like your smile.
Thank you.
You got it sold. All right. All right, Mrs. Zelaya.
Thank you. All I was gonna say is I got a plea across the hall, so you're fine.
What are we doing, Mr. D?
OT must defer to adjudication probation. Your Honor, I think it's a good thing for Mr. Guerrero.
He's got a bond violation today.
He came back negative, Judge.
Sent him for test?
Yes, sir. Mrs.
Yes,
Felicia
yes,
said
it
it.
was negative.
Wonderful.
Yes, sir.
Great. Good job.
Yes, sir. Appreciate it.
That's great. That makes me really happy, Mr. Fuller. Really. I was upset that you missed the appointment, but you came back, tested negative. That's great.
Thank
That's
you.
all we're asking, right? You know, because the thing is you're entering into a great deal, right? If you complete this, you don't end up with a conviction. But what you need to understand is that you give up nearly every right known to man by entering into this agreement. And it's a contract between you and the court saying, hey, I'm going to complete this agreement. If you don't, you authorize me to put you in jail for an entire year. So it's no joke. We routinely have to put people in because they just don't get it. We're not asking for much. And I'll make you an even sweeter deal. If you do well and you kick butt, I'll take you off in half the time. If you do your classes quick, don't test positive, be nice to everybody, because you got to understand you're meeting with probation officers. They're dealing with the worst of the worst all day, every day. So if you get in there at 4 o'clock, they're probably going to be in a very bad mood. So make the first appointment in the morning, go in there, crack a joke, be nice. You'll have the meeting out of your hand, you know? And like anything in life. Now, it's a 15-month deferred. Part of the agreement is for you to complete an effective decision-making class, a gun safety class. You must also do a TRAS. This is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them.
So, Judge, was it 15 months, 14 months?
15.
I have 15. But look, if you do good, you're off in 7.5 months. If you've really, substance abuse treatment as needed, no drugs, no alcohol, no weapons, forfeiture of the weapon, and 32 hours of community service. Is this how you understand it?
Yes,
Did
sir.
you graduate from high school?
I ain't graduate.
No, sir. No.
Oh, no, sir. No, sir. No, sir.
Well, how far did you get in high school?
Last time I was 10th grade, sir.
Hey, no, it's unacceptable. You need your high school diploma.
Sir.
In lieu of the community service, I'd rather him work to get his GED. You need your GED. If you don't have your high school diploma, every single employer is going to run circles around you. You will make pennies to when other people are making dollars.
Yes,
You
sir.
need your high school diploma.
So
That is my main focus of this thing. Once you get that high school diploma, I'll take you off.
yes, sir.
That's how meaningful it is. You understand?
Sir.
Okay, so what I want is let's set it off 3 weeks. And I want to know within 3 weeks that he's enrolled to start doing classes. Okay? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you are stuck with us until you complete it, or if it gets violated. If you pick up a new case, if you smoke weed, if you do something you're not supposed to do, I'm going to issue a warrant for your arrest. We're going to have a hearing to see if you violated it. And if you did, you're looking at an entire year. But I'm telling you now, I will keep you, and I can keep you for 3 years until you get your high school diploma.
Yes, sir.
We have services so that you can get it for free. So money is never an issue. And I will help you in any way that you need. But that's the most important thing in your life at this very instant. You understand? Okay. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm not gonna find you guilty. I'll withhold that. I'm gonna waive all your fees. It's never about the money. You understand? If you ever have a problem, you get a probation officer you don't get along with, come here, we can help you out. But don't just take off. It's the worst thing you can do.
Yes, sir.
Good luck, Mr. Camaro.
Thank you, Your Honor. Yes, sir. Thank you, sir.
All right, good morning, Ms. Lee. Ma'am, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Judge. On June 16th, 2023, a law enforcement officer conducted an investigation and made contact with the complaining witness. The complaining witness stated she was in the leasing office at an apartment complex. The defendant entered after she was given a criminal trespass warning. The defendant was yelling during business hours while the complaining witness had future residents in the lobby and office. The law enforcement officer issued a written criminal trespass on June 2nd, 2023. The defendant stated she understood the criminal trespass warning at the time. The law enforcement officer attempted to make contact with the defendant who refused to answer the front door, but yelled she was not going to open the door unless the law enforcement officer had a warrant. The defendant was identified by her.
Does she live there?
Yes.
I do not have any facts that demonstrate that in the officer's short statement.
Okay, so let's do this. Ms. Lee, I'll appoint you a lawyer today so we can get to the bottom of it, and then I can make a ruling a little bit later. What I'll have you do is I'll just have you sign a receipt with Victoria. We'll have you take a seat. Let me appoint you a lawyer, and then we'll have him investigate a little bit further, okay? Please.
This way.
Judge, can you sign bond petitions on downbeat? Yeah.
I'm approaching on Simone Lee because you'd expressed some questions about probable cause in her case,
Correct.
as I have myself.
Okay.
So this is her leasing office. She needs to go in there to access her mailbox, to access, various things. The time that she went in, received a so-called trespass warning, which when her car was broken in and she was expressing concerns about it.
My only issue is that a lot of people say it, but they're really not on it. So if you show me that she has like a lease with her name on it at that complex, that would make a huge difference.
Well, she left, but they even say it in the report. There's no dispute on the fact that she lives in there. She was in that leasing office because her car had been broken in. She has text on her phone right now after they gave her the trespass warning for her just trying to sit there while the police come. She would contact them and get authorization from them saying you can come in, just for her to check her own mailbox. So she has text right now on her phone that could show you she lived there, her contact between her and the office.
But I think at this particular moment, I mean, she goes in allegedly huffing and puffing, so they say, hey, get out. Right? And can you read me the DIMS again? State, please.
Yes, sir.
Only.
Looks like on June 16, 2023, the officer conducted an investigation, made contact with the complaining witness. The complaining witness stated she was in the leasing office of the apartment complex when the defendant entered after she was given a criminal trespass warning. The defendant was yelling during business hours while the complaining witness had future residents in the lobby and office. The law enforcement officer issued a written criminal trespass on June 2nd, 2023.
So we know that from June, there's a trespass warning that she can't go. Are you telling me after that, she has a text from the leasing office saying that she can go?
Correct. This is where her mailbox is. She has to go in.
Your Honor, from the bench report, it looks like the defendant came in and caused a disturbance, because her air conditioner was not working.
I'd be huffing and puffing too.
Yes, Your Honor. Apparently, the leasing office sent maintenance personnel to the defendant's apartment to fix the issue, but she refused to allow them inside the apartment.
Well, I don't know. So let's do this. Today's Friday. Let's set it for Monday for a formal hearing. See if you can get some kind of lease, because I'd like to know
Okay.
if she does,
You want me to
like
come back?
named lease.
Name,
Yeah,
please, and copies of the text messages?
sure.
Okay.
And then let's set it for formal probable cause hearing, because I don't know how you can possibly trespass someone where they live, and then you give them authority, hey, come back. Right?
Yes, Your Honor.
So we'll set it for Monday for a formal probable cause hearing. In the interim, I'm going to order her not to go over there. Come up, Miss Lee,
She's
until we figure this out. Say that again?
She does not live there anymore, but yeah.
It's probably a good idea.
Mhm.
Okay, we're going to set this for a formal probable cause hearing for Monday. Don't go back to this place. Don't have contact with the complaining witness in this case. It's not going to go well if you do. Just don't, and then all will be fine, okay? They're going to create those bond conditions. We'll have to sign it, and then after that, you'll be free to go, and we'll resume back on Monday, okay?
Eric, thank you, Judge.
Thanks. Don't leave until you sign those bond conditions, man. Okay. You are Luis Garcia.
Yes, sir.
Mr. Garcia, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On March 30th, 2025, in Harris County, Texas, a law enforcement officer was dispatched a welfare check on a vehicle and found the vehicle clearly stopped on the right-hand shoulder. Upon contact with the defendant, the law enforcement officer observed red glossy eyes and the odor of alcoholic beverage. Defendant admitted to consuming 10 beers at a bar before operating his vehicle. On the Friday test, the law enforcement officer witnessed 6 items excluding the HGN, unmotivated to walk into 3 or 4 on one leg stand. Defendant consented to a breath test and blew, I believe this to be an error in the binge runner, but it says 0.016 and 0.0156. I believe it to mean.
Well, it should be one. I don't know. I mean, you can look in the OR, I guess, just to see. Regardless, I think there's enough to go forward. Mr. Garcia, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? And does he have any prior DWIs?
Yes, Your Honor. No prior DWIs, and he is eligible.
Thanks. Mr. Garcia, I'm going, like I said, I'm finding probable cause. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you to see. If I find that you're consuming, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer, sir?
I have one already. I'll hire one. I'll be shooting on Zoom. She's shooting on Zoom. Romero Associates.
Rodriguez, Carlos.
Oh, Carlos. Ms. Broholm, are you here for a case?
Judge, I'm here for the non-disclosure. It's in your queue. I approached you on it on Monday. You said you granted, but we had a filing issue, so I refiled it.
Okay, I'll sign it. Okay.
Thank you, Judge.
Yep. Okay, so I guess let's do this. I'm going to have you sign a reset. I'll have you get with Fleischer for your bond condition, then we'll just have you wait for your lawyer to get here. Okay? Don't leave until they get here, though. Please. You're Noel Garcia Castillo. Sir, you're charged with driving while intoxicated. Second offense. Looks like they're going to reduce it to a first. However, it's still above a 0.15. So you're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 1 year in jail to be probated for 15 months. As part of this agreement, you will do a repeat offender DWI education class. You will do 2 victim impact panels. You will do, has he done a TRAS yet?
No, sir.
You will do a TRAS. This is an evaluation to see what other conditions you may need. You must fulfill any conditions that they state that you need to do. It could be intensive outpatient, it could be supportive, whatever it is, you must fulfill those conditions. You must do substance abuse treatment, no drugs, no alcohol. You must have a guardian interlock and perform 20 hours of community service.
So,
Do you have children?
Yes.
I would rather do a parenting class instead of this stupid community service that just, you don't learn anything. If that's okay, guys, you know? You must also have restitution in the amount of $1,000. Is it true or untrue that you had a 0.15 or above, sir? You know, from now on, whenever you get pulled over, officers, they're going to see 2 DWIs. What do you think they're going to do to you if they come to you and they smell alcohol?
You're gonna arrest me.
What happens next time?
Go to jail?
No,
No.
prison.
Penitencia.
You're looking at a minimum of
Lo
2 years in
mínimo de
prison, a
2 años
maximum
en la
of 10
penitencia, lo máximo
years
hasta
in prison.
10 años en
Now,
la
we
penitencia.
have to get a hold of you so that you realize that this is not a joke and that you should take this seriously. As part of this agreement, you will be required to pay the DPS fines and fees. And if you don't, every day or every $100 that you owe, you will sit 1 day in jail. Do you understand? Somehow we have to get a hold of you that you understand that this is not a joke. Your lawyer has worked an agreement that you're foregoing any jail time when there is a minimum of 5 days in jail because of the reduction. You now will be required to pay somewhere in the neighborhood of around $5,000 to $5,500. And if you don't, every $100 you owe, 1 day in jail. Do you understand?
¿Usted lo entiende? Yes.
About 100 and then whatever the fines are, you'll be required to pay. But first, I want restitution paid
Okay.
off the bat. He's got to pay the restitution first. And then, after that, he can start paying the fee.
Judge, I did file a, to waive DPS.
I'm not gonna waive it. No, he's not indigent. No. And he's already skirting the mandatory jail time as it is. So somehow we have to get a hold of you so that you see that we mean business. And I hope that this is it before someone either dies or before you graduate to felony status. There is no breath test refusal as well. If you were pulled over in a car, an officer asks you to submit a breath test, you must do it. If you fail to, then you're in violation of this probation. This is only while you're on probation for this case. Does he have a license to drive?
He does not. He hasn't been driving.
Don't have a license. The worst possible thing you can do in this short life that we have is get into a car and drive. If I find that you do, I don't care what your excuse is, you're looking at an entire year in jail. Do you understand? How do you plead to this offense? Guilty or not guilty?
Guilty.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, it's done and over forever. You can never come back and change this. Do you understand? Is this what you want to do? All right.
Yes, sir.
All right, sir. I'm going to find you guilty. So I'm ordering the 20 hours of community service. If he does a parenting class, I'll consider it waived in lieu of. All right. Good luck to you, sir. Thanks, Frank.
Yes. So reckless driving, Judge, do you want him up?
No. I had a bit of an issue with this. So that's why I wanted to appoint someone to see. Go to the left. Out of view. There we go. Okay, perfect. Okay, so can you read me the DIMS again, Alex?
Yes, Your Honor. So on March 27, 2025, in Harris County, Texas, officer observed the vehicle made an improper turn, nearly causing an accident with the vehicle turning next to him by turning into the wrong lane. Defendant then traveled at 80 miles per hour in a 50-mile-per-hour zone and made an unsafe lane change while speeding. Also, I watched the video for this one, so I can answer questions on what actually was observed or what I observed.
So let's break it.
Complaint, it basically alleges unsafe lane change. It doesn't really.
Is that the basis for the reckless driving, the unsafe lane change?
So the way that the charging instrument reads is essentially, in word for word, is a reckless driving vehicle in willful and wanton disregard of safety of persons and property by driving more than 35 miles per hour over the posted speed limit, making unsafe lane changes, causing other drivers to have to take evasive action and avoid collision with the defendant's vehicle.
Is that what you saw?
As I did not observe any vehicles having to take evasive action. What I observed specifically was kind of coming out of the parking lot onto Fear Road. He does cut across 3 lanes to go to the far lane. But I didn't see any vehicles having to take evasive action, slam the brakes on. In terms of speeding, I'm not sure if he was speeding or not, but it did look consistent with the flow of traffic with the exception of passing other vehicles.
I'm going to admonish you.
I think that's fair, Your Honor.
Come on. Who is it again?
Brandon.
Do you watch the news?
Yes, sir.
Do you really? Do you really watch the news? Every single day in our county, someone dies because of a boneheaded move that's made in a car. Every single day, not just one, multiple lives are taken on our streets just because people drive in such a manner that they end up killing someone. You know, yours is not the worst, and I'm going to find no probable cause, but be safe. You know, we're not asking for much. Don't drive unless you have a license. Don't drive unless you have car insurance. I tell you, I get so many emails every week because people, how can you help me? Because I have someone that's suing me for $50,000 because I got into an accident and crashed and I wrote their car. They literally ask me to represent them and help them because they don't know where to go to, where to turn because someone filed a lawsuit against them. If someone does that and you get a judgment against you, you're hosed. Get car insurance. And when you drive, do it in a manner that you're not going to injure or kill someone. We're not asking for much. All right.
We had a conversation about that already, Judge.
Be safe. It's not much. You know, if you got to get somewhere in a hurry, leave earlier. All right. All right. I'm going to find no probable cause in your case. All right. Take care of it. Be safe. If I see you back, it's not going to go well. All right. Peace. Thanks.
Mario Alamos, first setting.
Okay. Do you mind bringing him up?
Yes, Mario, come on up, please.
Full waive probable cause, Judge. It's, changing lanes with other vehicles present.
I'd like us to be.
Okay, I was.
Good morning, Mr. Alamos. Good morning. Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On March 29, 2025, in Harris County, Texas, a law enforcement officer witnessed a vehicle fail to maintain a single lane by swerving across lane lines with other vehicles having to avoid the vehicle and then failed to signal a lane change. Law enforcement officer conducted a traffic stop and made contact with the defendant. The law enforcement officer observed the defendant to have a strong odor of alcoholic beverage. Also observed there to be mouthwash on the vehicle and 2 beers on the floor. It's not saying if those were open or not.
Go to the touch.
I do not believe it says that either, Your Honor. It just says 2 Modelo beer cans on the passenger floor. As far as the defendant admitted to drinking multiple alcoholic beverages, SPSTs were conducted where the law enforcement officer witnessed 606 on the HGN, 204 on the 1-leg stand, and the defendant was unable to complete the walk return. The modified wrong burger was also concluded where the defendant had a slight sway and estimated the passing of 30 seconds and 13 seconds. The defendant considered to a breath test at 0.086 and 0.08.
Mr. Alamos, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm also now placing a further restriction. You're not allowed to drive any vehicle that doesn't have an interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. Do you understand?
No. Judge, may I answer your question? It's first CWI. It's
He has a prior DWI.
No,
He was dismissed. I see it.
That prior-
And now he's got alcohol in the car.
But no, just for the court's information, the reason why it was dismissed was he blew a .05. They had no reason to arrest him in the first place, and he can verify that.
Remember that they don't need breath tests to prove, it's just an aid to convict, just like breath tests, just like field sobriety test. Back in the day, no one had anything, right?
Mm-hmm.
So regardless, I want to know for the time being that you don't have any issues. Do you understand, or would you like me to get a translator?
No lo entiendo bien.
Okay.
Te voy a poner una máquina en tu auto. Tú no puedes manejar si no tienes una máquina en el auto. No puedes tomar alcohol, usar drogas y te voy a poner en exámenes para ver si estás tomando. Si tú tomas, si manejes sin esa máquina, te pongo en la cárcel. ¿Me entiendes? All right. Yo quiero saber que tú no tienes un problema y que no vas a matar a una persona en el calle. Right. If time passes and we're good after some time, come back and we can talk. But for the time being, I want to know that I don't have a problem.
That's urgent. So maybe 60 days or would he be hiding?
Tú tienes abogado, porque tú tienes abogado, no tienes que regresar a la corte hasta que ellos te dicen. Pero si ellos me dicen que no pueden contactar y no estás comunicando, voy a revocar la fianza. ¿Entiendes? All right. Okay.
Judge, I don't think we had an eligible license on.
We do not, Your Honor. I don't have a driver's license to run, but I don't.
He didn't license.
¿Tienes una licencia para manejar?
Sí.
De Texas?
Sí.
Yeah, he's been in the United States since 1990, 1980s, Judge.
Do you mind? Can we verify?
Sure. Close to the
Yeah. Just, are you able to do it, please?
No, we.
I can run it, Your Honor.
All right. Solamente quiero saber si tú tienes un válido y puedes manejar.
Judge, it's a,
Well, don't do it here because live stream, so I don't want the entire world to see it.
no, it expires 2020.
Okay, we're good. All right.
We got it.
Morning, Judge.
Hey,
How much are you? Running around.
yeah, I want to go back to bed. Good morning, Mr. Salas. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with evading arrest or detention. On that, you're facing up to a year in jail and or $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. So. Okay.
On or about March 26, 2025, an officer was on patrol on Gulf Freeway in Harris County, Texas. The officer observed a motor vehicle disabled in the left hand with grass B dividing southbound and northbound lanes of traffic. The motor vehicle had multiple airbags deployed and all 4 tires appeared to be damaged. On arrival, the officer observed additional motor vehicle disabled on the open access roadway of what was formerly a car dealership. The officer observed the witness walking towards, the officer trying to get the officer's attention. The witness said the 5 minutes prior to the officer's arrival, the defendant approached the witness after the witness side her out. The witness informed the officer that the defendant demanded to use the witness's phone. The witness advised the officer that the defendant wanted to contact the defendant's mother to pick up the defendant from the scene. The witness told the officer that the defendant continued to approach aggressively, and that the witness told the defendant, the witness would call the police if the defendant did not stop. The witness said the defendant fled the scene on foot. The witness described the defendant's clothing, and the officer observed the individual matching the description running and approaching the scene of the incident. As the defendant approached the scene of the accident, the defendant began walking in a parking lot adjacent to the freeway. The officer gave loud verbal commands for the defendant to stop. The defendant fled on foot on the grass along a ditch. The defendant slid down a ditch and then back across the Water Creek, then climbed the fence and attached to private residence, and fled on foot for approximately 0.4 miles before he was then detained by his police department, turned over to deputy. The scene was moved to a Shell station to continue the investigation. The officers contacted the defendant. The officers observed a strong odor of alcoholic beverage emitting from the defendant, and the officers observed the defendant had red glossy eyes, slurred speech, dry mouth, repeating phrases, and agitated demeanor.
You say shaky demeanor?
Sorry, agitated demeanor. And the defendant denied drinking alcohol and initially denied drug use, and then stated that he had been off for a couple of days and had consumed paste or coke. The officer, through training experience, knows this to be drugs and cocaine. The defendant admitted that he was going to a girl's house when the incident occurred and agreed to perform standardized field sobriety tests. Those were administered, and the officer observed success exposed on the HGN. The officer did not administer the walking tour the one leg stand due to the defendant injuring his feet while fleeing. The defendant consented to a breast sample, which was not completed due to interference being detected. The officer obtained a search warrant for the defendant's blood, and there was a blood draw.
Okay. You're not on Medicom. I might miss something, but besides state saying that my client said he was going to someone's house, I didn't hear any operation facts.
I mean, he admits driving. He's by the car when the officers get there, right? Is he by the car when the officers get there, or where is he?
What I have, Your Honor, he has fled the scene when the officers get there, and then comes back to the scene.
Okay.
To the officers. The witness.
Does the witness put him operating at all?
Yeah, just one moment, Your Honor.
Yeah, all I heard is going somewhere. It doesn't say he was driving. So you see how maybe why they might refollow, they might have the wrong corner. Sometimes they can be fading, it's getting go.
I'm not sure, Your Honor, there was anything additional. This is kind of weird. In this paragraph.
Hey, look at that.
See you again, Your Honor.
Yeah, what's up, man? Good to see you. You have anything else?
Your Honor, it does look like the witness stated that he stopped and exited his vehicle and observed the driver of the repo. That's what I have, but.
So it doesn't match up my
Taking the Patrick Martinez stated once he stopped and exited the vehicle, he observed the driver of the RAV4, identified as Abraham Elias Salas, using driver's license, come out from the grass near the RAV4 and aggressively approach him, requesting to use his cell phone. Stated that he was trying to use his cell phone to call his mother to come pick him up, and that Salas said the RAV4 belonged to his mother. Martinez stated after a short time that Salas asked Martinez if he had papers for immigration.
Judge, even with these facts, it doesn't show driving. Even if he owned the car, we have no idea when. There's no facts to say that he was driving the car, that he admitted to driving the car. I don't see operations.
So Salas stated that he was driving the RAV4 because he was going to a female's house and continued to speak. Salas then stated that he ended up in the grass because he was scared. Then stated that he was a Mexican driver that swerved in front of him.
He said a Mexican driver swerved in front of him. Is that what he said?
I told him no Tango Papeles or I don't have papers. Salas said the other driver was in a gray Toyota, telling him to go away. Stated that the RAV4 and the alleged Toyota came into contact, causing a collision. Salas stated that he was coming from his house in Friendswood, but denied having anything to drink. So
I mean, I think if they
he was operating the vehicle at the time of the accident.
and you have the other person say something, right?
They say that it was, they identified him as the driver.
They just never say they saw him driving or operating the vehicle.
So I believe that they believe based off the circumstances that he was driving. I don't know if the witness actually saw him driving. What we have to prove the driving facts is that Reeves got fired to a fleet prior to his arrest. He admits that he was driving the vehicle at the time of the accident, and the vehicle was found at the scene of an accident. He was found nearby. Was observed coming out of the grass nearby.
Although it's an admission, Judge, it needs to be an admission plus. I don't see that being enough for the plus.
Mr. Salas, I'm going to find that there's no probable cause in your case. Every freaking day in our county, someone dies from an alcohol-related collision. Don't become a statistic because of a boneheaded move that you make where you kill someone. Do you understand? Now, I'm going to find no probable cause. It's very possible they go indict this case at a later time if they get more evidence, but don't kill anyone. Do you understand?
Yes, Your Honor.
See.
Thank you. Are there any conditions you're imposing on the evading case?
No, I'm going to find no on both.
On both, thank you, Judge.
The judge found no probable cause in the Sally's DWI case, even though the man crashed 2 cars, fled on foot for nearly half a mile, jumped fences, slid into a ditch, and admitted he was driving to a girl's house. The judge's reasoning? Nobody technically saw him behind the wheel. So here's the question. Should a defendant's own admission of driving, combined with overwhelming circumstantial evidence at a crash scene, be enough to establish probable cause for DWI? Or does law enforcement always need a direct witness to operation of the vehicle?
Talk to me.
Desmond Smith. He's one of the ones that,
Yeah, ones. Okay. What's the last name?
Smith, Jasnick, fugitive, out of Louisiana, one of those 4 guys that you already talked about. He's the one that did not have he was a passenger, not the one with the weapon.
There were 3 passengers.
I talked to his mother.
How old is this kid?
He's awfully young. I can't take the computer, I don't. He looks awfully young. I talked to his mother. His mother's willing to post bond and able to post bond if it's reasonable.
Therein lies the question. What is reasonable?
1,500 would be reasonable.
He's coming back in.
I know. Nelson, did they respond?
What's that?
Did they respond on Nelson?
Smith. Then bring up Mr. Smith.
Okay, yeah, we're on Smith.
Okay. Smith's coming out now.
Black claims that they told them they were not going to mess with it. We're still waiting for the official word from Florida. What's the name of that city?
I don't know that, I just went by the county.
It's another one of those.
I've been mispronouncing.
Nectich.
I've been mispronouncing county.
Morning, Mr. Smith. How's jail?
Worst experience of my life, bro.
Makes me really happy. It's supposed to be. You know, the idea of jails are that you learn. And unfortunately, we have people that just don't get it. No matter how long the sentences are, no matter how cold the bars get, they just don't get it. You're wanted out of Louisiana for this car.
So,
your lawyer's asking for me to set you a bond, but I don't know. I've never met you before. I don't know you. You know, one of the things I consider is, number 1, are you going to go back if we set you a bond? Number 2, are you a dangerous person? Because I don't want to set you a bond and then you leave a wake of destruction on your way to Louisiana. I mean, I don't want that. So Mr. Kim, tell me about Mr. Smith.
Your Honor, this now defendant, along with 3 co-defendants, stole a vehicle out of Louisiana and transferred state lines on the same day and was apprehended in Harris County. He's facing a felony charge there. Due to the fact that they transferred state lines within 24 hours of stealing the vehicle, which was captured on surveillance video, state would be opposed to a bond as state considers him a flight risk.
Any prior criminal history?
No, Your Honor.
Judge, he is from Natchitoches, Louisiana, which is where the offense is from. His family lived there and he was born there. They moved to Manning, Louisiana. I talked to his wife and his girlfriend.
His wife?
Mother.
23.
His mother and his girlfriend. Okay. I spoke to his mother, Sophia Smith. She lives in Manning, Louisiana. She will post his bond. And I spoke to Sophia Smith and she'll come over and pick him up. That's, and transport him back to Louisiana.
Here's the thing, Mr. Smith, is I need you to understand that we don't play games. If I set you a bond and you make that bond, we give you 2 weeks to go turn yourself in.
I will, sir. I promise.
We don't play games. So if you fail to do it, I'm going to revoke that bond. I'll set it at 0. I'm going to issue a nationwide warrant for your arrest. I'm going to get you because you can't run forever. And the next time you will not get another one. Do you understand? Okay. I'm going to set you a bond at $1,500. Here's the other thing. Life is short. Life, when you end up with a bunch of convictions, it doesn't become a fun life. What makes life fun is You get knowledge, and when you get knowledge, you buy things because you get money. But you only do that when you go out there, school, learn, get a good job. That's what life is about. I'm not picking up convictions.
So I'm in college right now too, sir. That's why it's kind of creative. I'm
Really in college?
for audio arts.
And now with all this, really? Dude, when you hang with boneheads, it doesn't end up well, you know? Get a clue so you don't end up back here. Mr. Smith, I'm going to set your bond at $1,500. Just, Mr. Smith, don't disappoint us, man. Do something with your life. Don't become another statistic. $1,500 and then do right, man. It's not hard in this life, you know? All right, we got you. Buddy.
So if you can make it, I'll print out the reset for him to sign and I have the waiver withdrawal for you to sign.
I'll bring that. Don't send him back yet. You got some.
Yeah, so I'm typing up the reset right now, but the waiver withdrawal is there for you to sign.
You're Jeffrey Chauvin.
Yes, sir.
Mr. Chauvin, you're charged with criminal trespass. You're also charged with resisting arrest. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay, please.
On March 5th, 2025, an officer was dispatched to a trespasser call at a Whataburger in Harris County, Texas. Complaining witness and employee stated that she told the defendant who was in their dumpster in the parking lot to leave, and the defendant refused. Staff tried to tell the defendant to leave again at 1 a.m. and defendant really stated that he would leave in an hour. At 2 a.m. and 3 a.m., the defendant was still refusing to leave after being asked to do so multiple times. At 5 a.m., the trash company came. The defendant refused to come out, so they could not pick up the trash. The officer observed the defendant in the dumpster and asked him multiple times to come out and that he had been trespassed from the location. The defendant continued to refuse for about 30 minutes. The officer asked the defendant if he would be willing to go to the jail diversion center, and the defendant said yes. The officer handcuffed the defendant so he could eat food. Officers provided him. The officer went to reapply handcuffs, but the defendant resisted passively by not following officer commands to lean forward. The defendant verbally stated, "No, I'm going to keep my hands here." After several attempts and the defendant not following verbal commands, the officers removed the defendant from the vehicle and put him on the ground so he would not hit his head. While officers attempted to handcuff the defendant actively resisted by pulling his arms away from officers. The officers still took the defendant to the jail diversion center, but upon arrival, the defendant said he did not want to be there and just wanted to be released, so he was rejected. While en route, the defendant had taken his seatbelt off, put his handcuffs in front of his body. The officers told the defendant he would have to be handcuffed behind his back, and the defendant agreed. Officers told the defendant to lean forward, and the defendant stated, "No, you're going to have to shoot me," and actively resisted by pushing his body onto the officers in an attempt to escape from the patrol vehicle. The defendant stated he would stop resisting once officers loosened up control, and when officers did, he would go back to actively resisting by attempting to get out. The officer was eventually able to secure the defendant. The defendant broke the officer's nail on the right hand, and officer sustained minor bruises to his finger and forearm.
I'm charged with the assault on a peace officer, Mr. Chauvin. I'm going to find that there's sufficient probable cause to go forward with the case. Do not go back to this Whataburger. Do not go back to this Whataburger. Do not pick up any new cases and show up to court. When you show up to court, good things happen. If you take off again, it's not going to go well. We've already given you, this is your second PR bond. Do you understand?
Yes, sir. I was not told I had court the first time. I was homeless. I was sleeping in the dumpster.
Okay, well, I don't want you to say anything now because I don't want you to hurt yourself. Let me give you a lawyer. They'll be able to talk to the lawyer how to resolve this case. We're going to give you a future court date, most probably. If you miss it again, I'm going to issue a warrant. You're not going to get a third PR bond. Do you understand?
I have to remain in Houston until this.
Well, let me get you a lawyer. We can talk and try to see how we go forward. For now, let me just have you go to Victoria Sign Reset. I'm going to have you take a seat in the jury box, and then we're going to get you a lawyer here momentarily. Okay? Please. Are you Alfredo Gutierrez? Mr. Gutierrez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. As you can see, your lawyer is here with you, not in person, but on Zoom, so that you're not here alone. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay. Please.
Yeah, right, just one moment. Sorry, it's moved also this one.
Okay, no problem. Oh, I see you're also charged with unlawful carrying of a weapon. On that case, you're facing up to a year in jail and or a $4,000 fine. Okay.
March 25th, 2025, in Harris County, Texas, a law enforcement officer responded to a single vehicle accident and made contact with the defendant, who stated that he was just being stupid and spun out and hit a pole. The law enforcement officer observed the defendant to have bloodshot eyes and a mild odor of alcoholic beverages emitting from his person. The defendant admitted to drinking one beer. Standardized blood sobriety tests were conducted, and the law enforcement officers were 6 out of 6 on the HGN test, 3 out of 4 on the one-leg stand, and 3 out of 8 on the walking turn. The defendant consented to a breath specimen and blew .078 and .074. Law enforcement officers also found a loaded handgun in the center console of the vehicle.
Okay. Any prior DWIs?
No, Your Honor.
You've run as San Steve?
Yes, Your Honor.
Driver's license?
Still.
Mr. Gutierrez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? As long as you have a valid license and liability insurance in your name, then you may continue to drive. If you don't have either, then you're not allowed to drive, and that is also a condition of your bond. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Davila, and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games or you're ducking and dodging phone calls, I will issue a warrant for your arrest. Don't pick up any new cases. I'll have you go to Victoria Center reset. You'll get with Fleischer for your bond conditions, and then you're free to go. All right.
All right, Judge, how's June 3rd or the 5th?
You hear that, Ray?
June 5th, please.
Okay.
Okay, man. Have fun.
Thank you, guys. Bye-bye.
Take care. You are Mr. Scott Sanders. Mr. Sanders, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 25th, 2025, officers initiated a subject stop at a Walgreens on East Mount Houston Road, Harris County, Texas. Officers observed the defendant sitting outside the entry holding a brown cardboard sign, panhandling. Officers approached the defendant. Defendant stated, "Okay, I'm leaving. They told me to leave. I'm leaving. Don't take me to jail." Officers asked consent to pat down the defendant. The defendant consented to the pat down. The officers observed a green leafy substance in a plastic bag located on the defendant's person. The defendant stated he forgot the marijuana was there, but that it was only kush. Officers observed an additional plastic bag containing a green leafy substance. The officers observed the marijuana to weigh .045 ounces. The complainant was identified by their Texas driver's license and advised that the defendant has shoplifted multiple times and has been trespassed. Complainant was informed the officers that complainant was asked the defendant to leave prior to the officer's arrival. Complainant was advised officers that the defendant initially left the property. Complainant was unaware of the defendant's return to the store until the officers contacted him outside the store. Officers note defendant's theft case was against that Walgreens and was dismissed. Officer notes that the defendant has been criminally trespassed from the same Walgreens. Officers also noted that they did observe a meth or crack pipe on the defendant's person. The complainant was able to identify the defendant based on the previous mugshot.
Mr. Sanders, I'm going to find that there's sufficient probable cause to go forward with your case. Let me provide you a lawyer today so that you can talk to someone about this case. All right. For now, do not go back to this Walgreens. Let's not talk about this case because you have the right to remain silent. I don't want you to say something that hurts your case.
They want to say something about seeking treatment.
Okay. Let me get you a lawyer first and then we can talk about it and we'll try to help you as much as we can. Okay. Vic, do you mind?
Yes, Judge.
Okay. I'm going to have you sign a receipt, Victoria, and then we'll have you take your seat in the jury box, sir. Okay.
This way. Go ahead and sign for your step, please. Next judge is page 32, Williams. Come on up.
Good morning, Mr. Williams. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Okay. On March 25th, 2025, an officer was dispatched to Montrose Boulevard for a call for service related to the driving while intoxicated. The officers observed the defendant's motor vehicle upon arrival. The officers observed the defendant's vehicle to have major front end damage, multiple airbags reported, and to be leaking fluid. The officer met with the witness who called 911. The witness said he observed the defendant's vehicle to have struck a light pole. The witness stated that he did not see the actual crash, but saw the defendant back up and start driving away from the crash scene. The witness observed the defendant drive several hundred feet before stopping due to the motor vehicle being disabled. The witness stated that they observed, the officer made contact with the defendant, and the officer observed strong odor of alcoholic beverages emitting from the defendant's person. The officer also observed the defendant had bloodshot eyes and slurred speech. The officer observed the defendant had trouble maintaining balance. as well. The defendant consented to standardized blood sobriety test. The officer observed 6 out of 6 clues on the HGN test, 7 out of 8 on the walk and turn, and 4 out of 4 on the one-leg stand. Defendant consented to a breath sample, and which the test readings came back at 0.185 and 0.168.
Any prior DWIs? And then does he have a license?
No prior DWIs, Your Honor, and I'm running that license.
Please. Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail.
His license is eligible.
As long as you have a valid license and liability insurance in your name, then you may continue to drive. But if I find that you're using, it's not going to go well, and I will revoke your bond and put you in jail. Do you understand? Do you have the ability to hire lawyers, sir? Okay, we will give you time to hire lawyers. So I will first have you go to Victoria, sign a reset. You will then get with Fleischer for your bond conditions. After that, we'll get you out here to hire a lawyer. All right? Please.
That's good.
Good morning, Ms. Woods. Ma'am, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 26, 2025, in Harris County, Texas, officer was dispatched to a disturbance call. Officer met with the complaining witness who stated that he and the defendant were in a sexual relationship. Complaining witness stated that he and the defendant got into an argument over the Wi-Fi password. The defendant punched the complaining witness in the face and head, causing pain. The defendant also ripped the complaining witness's shirt, scratching him in the process, also causing pain. Officer observed the defendant to have visible injuries to his face and back.
Do we know whether he wants to have contact?
No, it's not.
He does not want to. Okay. Ms. Woods, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. I am ordering you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate this, we will revoke your bond and put you in jail. Do you understand me? You have the ability to hire a lawyer. We can have you fill out an application. I'll take a look to see whether you qualify. Deputy Miranda is going to give you an application. I need to know everything about you, where you work, what kind of money you make, money in the bank, car, what kind of car you drive. And then I'll take a look to see whether you qualify. I'll have you sign a receipt. Victoria will give you the application, then we'll have you take a seat in the jury box. Thanks, Mitch.
That's good.
And they're dismissing the felony upstairs, and he's doing yes for the probation with TRAS conditions.
Has a TRAS been done yet?
Yes, and your recommended IOP is SOP.
So with three.
No, shh. You have, or you're not you, but your lawyers have worked a killer deal for you today. You speak English, right? Where they're going to dismiss the felony in exchange for your plea on this case. I'm going to tell you now, this is not something that happens very often. So get a clue. Do you understand? Yes. The agreement that you have worked out here is you're now charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you have is 180 days in jail to be probated for 15 months. You need to understand that this charge is going to go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. Not only that, whenever you get pulled over, officers, the first thing they do, and the only thing they do when you get pulled over is they look at your record. If they see that you have a prior DWI, if they see that you have a prior felony, PCS, you think they're going to treat you good if they smell anything funky? Probably not. So don't give them the ammo to shoot you with a gun. It is a DWI, any prior DWIs? So the agreement is a DWI education class, 1 victim impact panel, a TRAS, but you have already done it. So the TRAS here is recommending intensive outpatient treatment followed by supportive outpatient treatment. This is what you must do. If you fail to complete these conditions, I will issue a warrant for your arrest. I will put you in jail and I'm going to bring you right back out in orange, and we're going to talk about whether you violated, and if you did, if you do, you're looking at 180 days in jail. Do you understand? No drugs, alcohol, random testing, and a guardian in a lock.
He has, we're going to do the portable because he's not driving, doesn't have a license.
Go be signing an affidavit today promising us you're not going to drive. Mr. Garcia, do not drive. If you want to see me grow horns and a tail, I'm telling you, don't drive. If you want to drive, do things the right way, ask for permission, get a license, get insurance, and then I will be dancing happily because you're doing things the right way. But if you go out and you do it on your own and you're not licensed, I'm going to lose it. You understand? All right. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I will send you to this agreement. Good luck to you, sir.
Thank you very much, Judge.
So, Judge, we have a,
Mr. Garcia?
no,
Okay, sorry. Good luck, sir.
Mr. Sullivan, Mr. Dixon, for Sullivan, there was a PC.
Loyola, this is the young lady that a few days ago you took into custody because she picked up a new case when she was out on our bond.
Right, okay.
She had the felony case. The felony is reset. She's here for her, I guess, arraignment on the new bond. But I think you had already modified her bond conditions 2 days ago. So,
Come up, Ms. Loyola.
we do need to talk about some driving issues though, Judge. So
She doesn't have a license. That's the issue. If I remember correctly, right?
I think you do have a license.
I was working on getting it fixed. It was, not an edit.
If you don't have a license and liability insurance in your name, don't drive. It's as easy as that. If you get your license, then we can talk. But until that point, I don't care what you have to do. I don't care what baby needs picking up. I don't care. You cannot justify getting into a car and driving unless you have a Texas driver's license and liability insurance in your name.
I was
You-
working on getting it.
Okay, working on it doesn't mean that you get to drive because you're working on it. No, no driving until you have a license in your possession. If I find that you do, I can have a contempt hearing, and every time you drive here forth, it's up to 6 months in jail and a $500 fine. If you pick up a fourth case, I'm going to lose it. Do you understand? All I'm asking you to do is follow the law. I'm not asking you to do Pythagorean's theorem. Okay, we'll give you a normal setting. Well, actually, no, we won't. The assault's at nearly 200 days now. Is this your case, Sebastian?
Yes, it is. I just,
Discovery complete?
I believe it is, Judge. I'm trusting.
Judge, it's the problem, it's the same transaction out of the felony court, out of the felony case. So I've tried to reach out to her felony attorneys. She tells me that it's bad communication with that particular person. So I'll have to try to really hard to find out because she's hoping
Right
that.
here.
Yes.
Mr. Gould, Mr. Gold is here. That's the lawyer.
I saw him today.
Did you speak to him? And does he know
Yeah.
okay, so I guess he knows the situation.
I tell you right now, Judge, it's bad. As far as the assault, the only thing is that there's some CPS records. I still don't know if the case is closed, because obviously they don't give it to us until the case is closed. But apart from that,
I mean, does that really come in this case anyways?
it can. I mean, so typically the things that would be in there is typically they do an interview with defendant, they do an interview with the kid.
I mean, unless it's relevant, I don't know, but.
Yeah. I mean, but you are right. I mean, it is a case by case basis.
Can you tell me when that felony is reset to?
The felony is reset to the 21st.
And is there an offer in the felony case?
I believe the note is. I mean, essentially the offer upstairs is that if she takes something on the misdemeanor, that'll get rid of the felony.
Okay, so they're set for 4/21. I'll give you the same day after the day it's clear trial here.
Gotcha. 421, Judge?
21. Right.
Is there any
I would
way-
imagine that's probably a global offer for everything.
Can we go 422?
Sure.
Okay.
But then she'd be coming that day and then the next day. She's on bond.
Right, I got you.
Up to you.
But hopefully I'll talk to her. If we can get the deal together, then I might just bring her back before then to get it done.
Okay, but after that setting goes clear trial.
I got you.
All right, John.
Thank you, Judge.
If you are charged with theft, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Has probable cause has already been found on this, right?
Yes, Your Honor. So she, it's already been found, but this case is really old. She didn't come to court. So this is kind of, she got rearrested for the same charge.
Okay, where's this from?
Your Honor, I'm sorry, just
Neves. Need, N,
yeah, thank you.
N-I-E.
Your Honor, the fifth date was October 11th, 2023.
Where from though?
Oh, where? I apologize. It was one more, Your Honor.
Can you look to see if discovery is complete?
Yes, Your Honor. It does look to be complete, although we'd have to talk about the videos. Yes.
Well, just to get this case, because they already had a prior PTI offer, which you're supposed to do an anti-theft course. They just reinstated the offers. They said that they'll still take the offer.
They said that they're going to keep the offer.
I spoke to them this morning.
Okay.
So she's going to complete this class this week, and I'm going to send it to them for dismissal.
Okay, this case is 1,269 days old. I'm now putting a monitor on your ankle so I know where you are at all times. You have 2 weeks to get this class done. If you don't, I'm going to set your case for trial. Do you understand? You get no more resets after that.
Okay.
Okay, all right.
Thank you, Your Honor.
So Felicia, if she can get today, please. You are Mr. Vasquez Lechado.
Yes.
Sir, you're charged with driving while intoxicated, facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 21 days in jail with credit for the 7 days that you have done. You're pleading guilty to this offense and it is now going on your record. You need to understand that from now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. If you ever get pulled over from now on, officers will look at your record. They'll see a prior DWI. If they smell alcohol or dope on you, it's probably not going to go well. So from now on, I would never, even if you have a sip of alcohol, don't get into a car and drive. It's probably not going to go well for you. You're giving up a lot of rights by entering into this agreement. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it goes on your record. It'll be there forever. Is this what you want to do? Yes. You plead to the offense guilty or not guilty?
Guilty.
I'm going to find you guilty. I will follow the agreement, send you to it. I'm now going to suspend your ability to get a driver's license for 90 days. Do not drive until you get a license. And good luck to you, sir. Thank you.
And Your Honor, if I may mention, I did want to mention something else, Your Honor. This was a case that I was appointed to maybe like 2 days ago. I did speak to Mr. Vasquez to let him know that not all the evidence is in and that he does have the right to that. He has been in custody since January. He got transferred to ICE, which he says he no longer.
So you need to understand that not all the evidence is in this case. By getting all the evidence, it's very possible that she may have a chance to fight your case and beat it. Once you plead guilty, there's no turning around. You cannot come back and return this like you don't like it from Target. Do you understand? Do you want more time to fight the case or do you want to continue with this plea?
I'm fine like this.
Okay. All right. I'll make a documentation that
Thank you, Your Honor. I appreciate that.
it's against your.
Yes, Your Honor.
All right, come on up.
How you doing?
Hey, Judge, good morning. This is Mr. Dalen Calhoun, Judge.
I'll sign this real quick. Don't say anything about the case, okay? Oh, that's. Use the focus of this. Getting to the proper place to handle your business. That's right. That's right. I'm so confused.
Scott Sanders?
Okay, what's his name?
His name is Jalen Calhoun.
Good morning, Mr. Calhoun.
Good morning. How much you doing?
So it seems that you are one of 4 co-defendants that we have on a case arising out of another state.
Yes, sir.
You are wanted out of
Louisiana, Natchitoches Parish. I butchered the pronunciation, but.
Natchitoches.
Natchitoches.
What is it?
Natchitoches.
That.
Louisiana.
Lawyer is asking me to set you a bond, but I don't know. I don't know you. I've never met you before, and I have a very short amount of time to get to know you to see what kind of person you are.
Right.
Paper really tells me who you are. The words coming out of your mouth, I just right. So, tell us about Mr. Calhoun.
Your Honor, he's wanted out of Louisiana for transfer and possession of stolen vehicles, not equivalent to theft of a motor vehicle, and him and 3 other individuals, one whom is charged with UUMV, were found same day where they stole a vehicle. We have a parallel charge with Louisiana where they're charging him for the theft and we have for the driver.
But the thing about it is, I wasn't there.
Don't you really think that you can just start spitting out something? Where do you think you are? Really?
My bad.
You think that this is helping you, Mr. Calhoun?
Sir.
You're not at home. You're not on the street. Okay. Yes.
Your Honor, the same day that they stole the vehicle, which was captured on surveillance off campus, they transversed state lines and came to Texas, and they were found in Harris County with obviously traffic infraction being the probable cause, and found with all 4 occupants of the vehicle. The fact that they transversed state lines, they would be opposed to a bond. There was also, and because I took a charge, I know before the officer reports out, is that there was also a firearm found on one of the passengers and that they were trying to conceal. At the time, the officers were getting everybody removed from the vehicle, and obviously 2 of them being under the age of 21. So they would be opposed to a bond for.
So hold on a second.
Yes, Judge.
It's a stolen car.
Yes, Judge.
Out of Louisiana.
Yes, Judge.
They come to Houston.
Yes.
All 4 of them.
Yes.
How do we know the other ones knew that it was stolen? Do we have any kind of?
In Louisiana, and they did it in real time. And the complainant stated none of the occupants in the vehicle had permission to take the vehicle.
I know that.
Oh, no.
How do we know that they knew that it was stolen? Right? So what if I come pick you up in my car?
Oh,
it's a stolen car. You have no idea it's stolen. Like if everything's ripped off in the inside, you got like, there's a screwdriver for the steering wheel and the steering column's been ripped off. Then there's facts that lead you to believe that it's a stolen car.
So for running the plate because it was reported stolen, and the fact that it was, well, at the time of the, I'm sorry?
That's still.
No, again, on surveillance video in Louisiana, that they have it in Louisiana, that these are the original individuals that stole the vehicle. That's how they knew. That's how the officers in Harris and the officers in Louisiana knew that they knew it was stolen, because they were the ones who stole it.
They have them, you're saying on video?
Yes, that's
All
what I'm
4
trying to.
together is taken?
Yes, that's what I'm
Yeah,
trying to
well,
get.
that's something.
Can we see this video? I haven't seen this video. It's
You're not gonna get to see the video. That's what the
That's in
underlying criminal
Louisiana.
case.
well, you're basing your decision on a video that the prosecution that says he saw, you haven't seen, I haven't seen.
I just want to know how they impute the thievery to him.
Correct.
And he's saying that
they're
there's a
saying it's because
video.
it was surveillance video.
And the Louisiana officers were telling the Harris County deputies that they have it on surveillance video. That's how.
Specifically what? Where was my client? Was he the one?
We're not gonna get all that.
Right. But we're talking about that.
Our criminal history?
No, Your Honor. This is based on flight risk. They literally transverse lines the same day they stole a car.
It hasn't been proven that he knew it was stolen.
How many got charged with the UUMV?
The driver, because that was the only.
That's the only one.
Driver, right.
So your position on bond is what?
There's no bond because of the flight risk. They literally fled the same day within 24 hours, really 24 hours within stealing a car. Judge. They literally fled the state.
They keep
stealing
saying
a car.
they stole the car. He didn't get charged with stealing the car. He's not in the vehicle. He is charged with transfer.
No.
He
He is charged,
he is
but in
charged.
Louisiana.
Oh, well, then that's a,
He is charged, but in Louisiana.
okay, well, he's
Here,
being charged with
he's been
that.
charged
Just
with
because he's charged with it doesn't mean you're going to convict him. I see like very good arguments as to why he shouldn't be convicted. Secondly, if we're talking about flight risk, he was a passenger. He hasn't had the opportunity. Where was he going? Did he know he was fleeing the jurisdiction? He doesn't know that it's stolen. Like you said, is the steering column broken? Okay, at that point, perfect. He should have known. There's nothing to say that that's what happened in this case. We're assuming the worst. Let's assume the best. He's presumed innocent. Let's not assume that he knew he was committing a crime. Let's presume he was innocent. So in that case, let's give him a bond. Let's allow him to go and fight this case. He can't fight it here. He's fighting an allegation that we don't have, the surveillance video that we haven't seen. Let him go fight the case over there.
21, sir.
I still stand on no bond.
I mean,
I'm ready to flight risk, and so.
well, you got to understand, in life, there are consequences to action, right? When you hang out with dogs, you get fleas. I can set you a bond, but you need to understand from the time that you're released, we give you 2 weeks from the date of that release to go turn yourself in to that parish in Louisiana. If you fail to do that, I will revoke the bond that I'm going to set here. I'll set it at 0. I will not give you another one. You can't run forever. At some point, we'll get you. And then that time, when we do get you, I will physically hold you until Louisiana comes and gets you. Do you understand?
So if I go down there, I'm at the bond down there 2 months.
That's correct. Right. The thing is that I will probably set a bond around $5,000. You'll probably have to make all of it because you are a flight risk. You're wanted out of another state. If you waived yesterday, we have buses coming in and out of Louisiana about 2 times a week. So if you keep the waiver, you'll probably be back Wednesday, at the latest, Monday, you'll be back in Louisiana Monday-ish, where if you want to bond out, you can, but you're going to have to make it on your own to Louisiana. And then you'll have to bond out. Or no, you're going to have to turn yourself in over there. You can't bond out. Is there no bond set?
I believe it's no, I'll double check.
You'll have to turn yourself in there. So if you want me to set a bond, you have to withdraw your waiver and you're going to lose the credit that you've built up toward them. Because if Louisiana doesn't come get you here within 14 days, we release you regardless. And then you don't pay anything. You're going to get released. So I'll let you talk with Ricardo and make the decision what you want to do.
Yes, sir. What amount would you be thinking, Judge?
5,000.
5,000? Judge, he is 21 years old.
Yes,
he would be seeking the support of his parents. It would be a bond that he's got to post 100% on. Would you consider going to 2,500? No? Okay, fair enough. I'll talk to my
You'd
client.
even get a bond, Mr. Calhoun, really. And I don't even know if I'm going to do the other ones as well, you know? I mean, I don't know. So
I'll talk to my client, Judge. Thank you.
Appreciate it. I'll just read you the PC summary again. So on March 23rd, 2025, in Harris County, Texas, officer was dispatched to a disturbance call and met with the complainant witness and stated that the defendant is her husband. The complainant witness stated that she told the defendant that she was going to move back to Arizona that day and they got into an argument. The defendant then told the complainant witness to hit him in the face. The complainant witness then struck him in the face 3 times.
right.
The complainant witness then stated 10 minutes later, she went into the bedroom where the defendant then lay down on top of her, grabbing her wrists, causing pain.
That's 10 minutes later.
That's 10 minutes later. Grabbing her wrist causing pain, complaining witness then got one arm loose, grabbed the defendant's genitals causing him to let go. And then the defendant then struck the complaining witness in the mouth causing pain. And the officer observed the complaining witness to have bruises on her arms and injuries to her top bottom lip.
How is it?
I think we are omitting some things that's pertinent to the decision that you're going to make.
What?
She asked, her daughter told her that you have to make a choice between.
Oh, that's right. Yeah. I remember. And then she makes a choice of him.
And she said, I'm leaving you and I'm going to be with my daughter and grandchild. And then he comes and tell her, if you're really that mad at me, then hit me. And that's when she went to him and hit him twice. Boom, boom.
How is it fair that I find probable cause on him and not on her? Why didn't they charge her?
So I would say one is the fact that he quite literally says to hit her or to hit him.
Can't consent
Well, but that's, I
consent
mean.
to an offense, Judge. If he
can't
tells me
consent
to
to
shoot
assault.
me.
Yeah, no. I mean, you can, like, boxers consent to
You can
assault,
consent to
right?
assault. That's.
But I mean, in this.
I think where we are for PC purposes, as far as this offense goes, is that it occurs 10 minutes later. Then we have essentially in a situation where he can't essentially claim self-defense if he's the one being the aggressor first, where he's grabbing her 10 minutes after this kind of initial incident happened. He's grabbing her and then she grabs his genitals and then he punches her in the face. I think that's where we're at as far as PC goes.
I don't think that's the law, Judge. I don't think you can avoid what had happened earlier just because it was 10 minutes later. I don't think you can take the fact away that she was the one that instigated and was the culprit of the initial assault.
But there's a long cooling down period. You know, if it's like maybe a minute or two after the fact.
I would say.
And then, but nevertheless, though, how's it fair that she's not charged? I mean, why does she get the benefit of the doubt? Because she's wearing a skirt.
I mean, the code does say you can consent to assault.
If you consent to, if you tell me to shoot you and I kill you, you don't think the cop gonna get me for murder?
Well, you can't consent if there's serious bodily injury involved. You can't consent if there's no threat or actual serious.
Come on, Mr. Sullivan.
Less than a serious.
I mean, an assault does occur in this case with him and her, but there's also another one that occurs, you know, so.
I would argue, Doug, that at this point, with the charge that we have, that's going to be fact issues that I'm sure we're going to parse through moving forward, but I think that's.
And I think it'll work to the benefit, you know, so Mr. Sullivan, I'm going to find that there's sufficient probable cause to go forward with your case. Don't have any contact with this person, please. The only thing I'm going to ask you to do is don't pick up any new cases, don't have contact, and don't be possessing weapons. I don't know why they didn't charge the other person. I don't understand, and I don't know. But be it as it may, just don't have contact with this person. I think that, you know, it's just could be like a rumbling volcano, and the last thing we want to do is we don't want anything more to erupt. We don't want further charges, and just, you know, and I think that, you know, they'll take it into account when you guys are talking about this case, but just stay away. That's all I'm asking you to do. Okay.
But Judge, with all due respect, I don't think it's too late to not to file charges against that person. I mean, I've seen cases where there are 5 charges.
That's not me. That's up to the DA's office and intake, whether they.
Then I think the DA's office should take that in advisement to file charges against the person who was the actual initiator of the contact between these parties. If they do it all the time. I've seen cases where the district attorney filed cases 1 year later, when they know that there was evidence to substantiate the filing of a charge against somebody.
Who knows? Maybe it will. I don't know. Do you mind filing no contact, no weapons? I've given you a lawyer. All you'd have to do is just stay in contact with Mr. Dixon. He'll tell you if and when you have to come back to court. I'm going to waive your appearance so you don't have to waste your time coming to court. Just stay in contact with him and he'll tell you if and when you have to come back. Don't leave until you sign the bond conditions. Once you sign them, you're free to go.
If I get some.
Go, take your time. Just come back.
Okay, I will. Thank you.
Take care, sir. Great. This gentleman with you.
He is co-defendant with the other one, Your Honor. If I may, I'll wait. So I heard everything y'all said. Do you want to go first before I start my spiel here? Which co-defendant?
Oh, yeah. What's the last name?
This is Doty. This is Doty, DOT1.
So, Mr. Doty, you're wanted out of the state of Louisiana for a particular charge. I think it's like a theft or whatnot of a car. Your lawyer, are you asking for a bond? Your lawyer's asking me to set you a bond, but I don't know. I've never met you before. I don't know anything about you. The way I get to know you is how you look on paper, because that really tells me who you are, whether to grant you a bond or not. The good news for you is that if it doesn't happen, we have so many buses coming in and out of Louisiana into Harris County, because we have a lot of Louisiana people here, that I'd say might be once, at least once, if not twice a week, there are buses coming in and out of here, shuffling people to and from Louisiana. Mr. Kim.
Your Honor, same as the previous approach, is that this is one of 4 occupants of the vehicle of a vehicle that was stolen early that day in Louisiana, and they traversed the state lines, being apprehended in Harris County. State would be opposed to a bond due to flight risk of traversing state lines. The same day they stole the vehicle, felony out of Louisiana, where they were captured on surveillance video.
Any criminal history?
No, Your Honor.
If I may, Your Honor, he has no ties here. He lives in Natchitoches County, okay, Parish, I'm sorry. He worked, his address is 500 North Street, apartment, what did I say?
A4.
A4? H4, Louisiana, zip code 71457. He lives there with his mother, Cynthia. He, 2023, got his GED from a program there called Ben Johnson. He also works at Pilgrim's Pride, which is the chicken plant. And so why are we holding him and paying him to pick him up? I would ask for general order bond, and he's going back to Louisiana. He's not staying here. That's where he lives. That's where he resides. And he can go post bond, get his lawyer, and deal with it. If he was charged with this in Harris County, this would be a criminal trespass. He's not the driver. The driver's charged in the 177th for unauthorized use of a motor vehicle. So if the appropriate charge in Harris County, if they had even been charged in Harris County, would have been a misdemeanor trespass.
I'm not going to give him a PR bond. I mean, he's a fugitive one from another state.
Well, he's an 18-year-old kid. I would ask if you would go lower than.
You need to understand, Mr. Doty, that actions have serious consequences. You're only 18. Are you 18? How old are you?
18.
You're just now starting your life. And when you hang with dogs, you get fleas. We have enough people in there now that become statistics, all they do is they end up running with the wrong crowd, end up with convictions, and essentially ruining their life. Once you become a convicted felon, it becomes extremely difficult to get a job, to get any kind of position of trust. People don't trust convicted felons. You don't get a good job when you're a convicted felon because no one trusts you. They're always going to think in the back of mind, okay, is this guy going to steal from me? Is this guy going to do this to me? Is he going to? You're on the road fast with what's happening now. Your lawyer wants me to give you a very low or free bond, but I can't. You are wanted out of another state. You are an inherent flight risk. And the problem is, any bond I set here now, because of the nature of this case, you're going to have to pony up a majority, if not all, of the bond because you're wanted out of another state. The thing is if you don't have anyone to pony up that money, your mom is a single mother, she's probably working her butt just to make it survive. You think she has enough money to just pony up money to get you out? This is what you need to think about when you start running with the wrong crowd. Because if you ain't got anyone to pony up money to get you out, you're stuck like Chuck until whatever happens with you. And I'll tell you now, more people plead guilty just to get out than they should. Because no one's going to wait 5 months just to fight a case. I don't know what an appropriate amount is, Greg, but it has to be sufficiently high that he's going to go back, you know?
But he's got to go back. Was he going to stay here? He doesn't,
you know, how?
He doesn't have anyone here.
How's he going to get back?
Gets out,
He takes
calls his
the Dodge
mom,
Pocket and walk
his
back?
mom, his mom provides transportation.
Have you talked to mom to see if she,
I'm going to call mom. I was going to see what the bond was, see if she can get him out.
call mom, and I want to know if she's going to come here and pick him up, and then we'll talk.
Okay, thank you.
I don't want to set people up to fail, but if he's got no ride, if he doesn't have anyone, then,
Okay.
you know,
Thank you.
let me know, Greg. And hey, Greg, if she does, I'm willing to go a little bit lower.
Okay, I'll try to get a hold of her. Thank you. No.
That's fine.
Oh, good morning, Mr. Butler.
How you doing, sir?
Your lawyer is asking for me to set you a PR bond, but you just picked up another case. Why are you looking at me all confused? You've got a long list of criminal history. You're on bond for a felony unauthorized use of a motor vehicle, and now you've picked up a theft. What happened in the theft, if you don't mind?
It is a retail theft, Your Honor.
Silly.
He was observed, surveillance video placing merchandise in a black suitcase he obtained from business and across all points of sale without attempting to pay. It was in Target, Your Honor.
You know, the funny thing is that it would only cost $100 to get you out of jail. You now know you have no one in this life that would pony up $100 to get you out. Why? You're just, why would we do this?
I was getting close. I had to. Okay.
I don't want you to talk about the case, but Mr. Butler, with all your criminal history, who do you live with?
I live by myself, but somebody is like living there, so I can't even get inside the place while they good. So every time I go,
I'm not giving you a PR bond so you can just go roam the streets. If he has, like,
I have an address.
some familial place, like a mop or, you know, uncle, aunt, I'd consider. I'm not letting you out just for you to go roam the streets and up to no more good. No, that's not what we're doing. So if you can figure out something, he's got some family or somewhere where he can go, and I know he's got a bed to stay at, then let's talk. But until that point, no, not to the street. You know, nothing good happens on the streets. And if I let you out, I'm going to have you come testing all the time because I don't want you using anything. Do you understand?
Sure.
Okay, so figure it out and then let's talk, but not to the street.
All right, appreciate it. Thank you.
Yeah. You have the,
Am I approaching?
No, we're waiting for.
I'm ready when you are.
For my guy? Oh, they got
You
it.
can bring him out next.
Okay.
Good morning, Mr. Living. How you doing? Oh my goodness. You were wanted out of the state of Nevada for, number 1, robbery with use of a deadly weapon or tear gas, ×2. Burglary while in possession of a firearm or a deadly weapon, ×2 counts. 3, kidnapping, first degree with the use of a deadly weapon or tear gas, ×2. Number 4, conspiracy to commit kidnapping, first degree, ×2 counts. And 5, conspiracy to commit robbery, ×2 counts. Are you waiving formal extradition, sir?
Are you waiving the proceedings that we talked about? You want the 14 days? Yes, Judge, he's waived.
Okay, good luck, sir.
Thank you, Judge. Does he need to sign it all?
He does. He needs to sign right there.
Okay.
If you need a pen, you got one?
I got one, Judge.
That was Living. Living, I'm not done with you. You had Civil War, you want some? Okay, thanks for that.
Appreciate it. What's that called about the dirt man? Okay. Oh, what? That's like pretty other lost.
Lamar Mesa. Is discovery complete on this house? Same.
Your Honor, just one more. There was surveillance video that we just looked at. It's obviously. And 21 camera, dash camera, and surveillance video. I can prove that.
Please get on it. This case is 1,256 days old. If you ever take off on me again, I'm going to make your bond so high, you're going to have teeth falling out. Do you understand? As of today, I will get an ankle monitor so I know where you are at all times. I'm giving you 30 days from today to make a decision on what to do in this case. We will either set you for trial or you must accept the plea bargain from the state in 30 days. And like I said, you ever take off from me again, your bond will reach the clouds. Do you understand? Where is this is this a co-defendant of the other one? I mean, are they the same day for real? Remember the one we had earlier today? Ms. Okafor.
Correct.
Oh.
What was that? Defendant, what was that one? Nieves, was that?
1269.
Oh. This one, it's not a code. It's a hearing case.
Oh. So where's this one from? Is this Target? Is this?
This is from J.C. Penney.
I'm ordering you as a condition of your bond not to go to any J.C. Penney for any reason. Do not pick up a new case. And I'm going to tell you now, Mr. Lamar Mesa, I'm going to do everything in my power to protect my community at all costs. If I find that you're a danger to my community, I only have one place for you. Okay?
All right, 30 days?
30 days.
Okay, thank you.
Do not leave until you sign our bond conditions. Don't worry about filing it because I'm having it monitored, so we can do it with Felicia. All right.
Client, told me that he has a VAWA case pending,
It's a what?
VAWA case pending in immigration process.
Okay.
So we have an offer. I asked, are you ready to plea or not? He's kind of like iffy about it because he doesn't know how that's gonna affect,
We need to.
Can we get a short recess just so he can get an appointment with his immigration attorney and see if, we don't have a lot of options. It says plea or trial at this point.
And I'm going to tell you now, I'm a time served on a second. Yeah, just so you know.
I
Okay.
told him because at probation, ICE might pick him up in one of his check-ins and time serve is ideal for him in his situation, but I think that we can just get his dismissal
Yeah,
tomorrow.
we don't. So, okay, I'll give you a week.
Yeah,
Okay.
and I'm gonna tell him just check in with the immigration attorney by next week, and if not,
So,
trial, that's pretty much it. Senor Ramirez? He's a Spanish speaker judge.
so do I.
Oh, yeah, I forgot about that.
Tu caso ya tiene 200 días. Es tiempo para tomar una oferta o poner tu caso en jurado con juicio. Tú tienes una semana para hablar con un abogado de inmigración y yo no te doy más tiempo después de una semana. ¿Me entiendes? Si no lo tienes hecho, no me importa. Vamos a ir adelante. ¿Entiendes? Ok, una semana.
Okay, all right. Ahorita lo vamos a ver. Thank you, Judge. Thank you.
After nearly 2 hours of hearings, DW is stolen cars crossing state lines, domestic violence, a man living in a dumpster, and a defendant wanted for double kidnapping with a deadly weapon, this judge handled every single case without losing his composure. But look closer. He questioned why a wife wasn't charged when her husband was. He lectured an 18-year-old about ruined futures. He refused to release a homeless man to the streets with nowhere to go. So the real question is this judge doing justice? Or is he doing social work from the bench? And where exactly should that line be drawn in a courtroom?